Vale. Vale. వస్తుంది అగో సౌండ్ వస్తుంది. ఓకే, ఇప్పుడు నేను కూడా వస్తాను, నన్ను కూడా వచ్చేసి మ్యూట్ చేయి.
Page number 2, item 32.
Sir. At 27, Jaypal Reddy and Srivas Kumar. August page.
Page number 33.
Huh? 23. After 6 and post after 4 weeks.
Page number 3, item 28, 35. Page number 4, item 36 to 47.
Post correspond 6 and post after 2 weeks.
Page number 5, item 48 to 61.
Yes, sir. Samathan, 6 for 2 weeks. Then wait, sir. You have to wait for the.
Page number 6, item 60, 75.
Item 73. They have implemented.
They have demands. Section already. Section of demands already there. Also down there. Okay. Post correspondence 6 and post after. I have to note, sir. Wait, sir.
Here is something.
I will tell the matter, sir. There are details.
Page number 7, item 76 to 86. Page number 8, item 87 to 93. Page number 9, item 100 to 112.
Post about 6 and post of 6 weeks.
Page number 10, item 113 to 115. Page number 11, item 128 to 142. Item number 1.
130,
130.
130.
Yes. Maybe posted after 1 week.
Go, madam.
55 million.
The 6 and post after 2 weeks.
It was disconnected Millard. Next week I informed other side Millard.
1 minute, sir. Wait. 1.
138 million.
Wait, 1 minute, madam. 130.
8 million. The distribution matter million. 84 is today.
Will reach, sir. Wait. Yes, madam.
At least notice will be happening.
Straight, sir. 4 to 30 before this phone. Yes, sir. 121, 1 to 0. Yes, madam. And remember outside. Hospital in 6 and post after 4 weeks. Yes, sir. What is your name? Representing to code.
Item 55 million. Rajikumar.
By traveling car. Yes, sorry. Yes.
Page number 12, item 143 to 150.
Item 151. 21.
Then go other side.
Inform.
After 6 and post after 2 weeks.
Page number 13, item 160 to 173.
Post after 6 and post after. Madam, you have informed outside. Only Babu. Post after 3 weeks.
Page number 14, item 174 to 188. Item number 188. Under the threat of eviction, your lordship, he has been added the road post and he has been
See, madam, we don't know whether it reaches or not today.
Page number 15.
Then, no, madam. See, madam. See tomorrow. Today evening.
Item number 55 million. I have already informed.
Sorry, sir. Not permitted, sir. Sorry. Yes.
Page number 15, item 189 to 200.
Item 199. For extension of 50. 230.
After that, 3.
Your Lordship, and for the respondent in this matter, Your Lordship.
Madam, 4:30 I will see.
Obliged.
4:30 I will definitely
It
come.
may be
Well,
taken up
item
next week, Your Lordship, and interim order may be extended, Your Lordship.
Wait,
It may
madam.
be taken up next week.
See, madam, after 4:30 only.
Page number 16, item 201. Page number 17, item 2142, 222.
Madam? 196. Not 196, madam. 192. Wait for 4:30, madam, please. 4:30. Mr. 4:30.
Page number 18, item 223 to 233.
Madam, 225, dispose of. Let's go. Yes, call the list. One, sorry, one by one. Wait, madam.
CRP of got statement. Transfer OP is pending.
Sir, 2 weeks, after 2 weeks. No, sir, no, sir.
May I please, Your Honor? My lords,
Last week matters has been not listed, my lord. Landlord tenant issue. The tenant even not paying the rents, my lord.
Post after 2 weeks. Adding up this 2 weeks.
my lords,
55, my lord.
CRP, 2 weeks, after 2 weeks. Yes, madam. Letter to the registry, madam. There is a court slip. What is the necessary the court slip? By letter to registry.
CRP of 2022.
Adding this post after 2 weeks.
To the level matter.
Post after 2 weeks. What are available? Choice is one. Next, call the list. No, sir. No. Yes, call the list.
my lord, item number 237, my lord.
Don't mention like that. So that's our
Item number.
car. NBA for 4 weeks.
Item number 2, please, Kumar Kaur.
NBA for 4 weeks.
Page number 2, item number 3, please, Ratna.
NBA for 4 weeks.
Item number 4, A Vijay Singh community.
Yes.
IA1 is condition left 250 days.
Yes, I want to respondents. Post after 8 weeks. Also, after our tech court for the service.
Item number 5. A Arvind Kumar.
Yes. I have an order. Admit notice post after 8 weeks. Post for apparent or tech court for the service.
Item number 6, C Mohan Prakash.
Yes. I have an order. I have 2 respondents. Post for apparent or tech court for the service. I have 3 post along with main case.
Item number 7, A Ramakrishna Reddy.
Yes.
We have 3 days in filing.
I have an order. I have to create conflict of for the records. 3 have 3 days condoned. I have 3 stay for around 6 weeks. This is main case admit notice post after 8 weeks.
Item number 8, C Mahendra Rao.
Yes. I have an order. I have to stay to have 6 just within 6 weeks. Main case admit notice post after 8 weeks.
Item number 9, B Achuta.
To the Ram. Pass over.
Item number 10, C Venugadu. Yes, Chandramohan Reddy.
Yes, sir.
I file the case.
Will it pass or not, sir? Where is Ken? Where Madhav? Ready? Pass over. Good. For the next case.
Item number 11. KD Raj.
Yes, madam.
In transfer to Balkach, mutual Balkach, that's to HIGHCOURT. Because my loss, the petitioner is and the respondent is the husband. Petitioner, my loss, I have seen that she is.
Don't say all these things, not notice to the respondent, madam.
Obliged, madam.
That the husband card also was advocate.
Yes, yes, my loss.
Resolution post after 6 weeks. Post per week. Take out offer service.
Obliged.
Madam, between the Warangal to Mahbubnagar, Hyderabad is middle, madam. Not for the distance, but not equal. You are saying that Hyderabad or Medakanagar means
Client told that the distance here from
you are not last minute of
and
No.
Konda are the same. So,
between Mahbubnagar to Hanmakonda, Medakanagar is between, madam. In between. Medchal is not the nearer to.
but her parents are also staying in Warangal. That is
No,
also
no.
there because they are.
She is working woman in some place Mahbubnagar.
She's working.
She filed in Hyderabad. But
Yes,
she came to transfer to Hanmakonda.
because earlier also she filed.
Okay, we'll see after one. Not notice.
Page number 12. Up to 30.
There is a 498 case is booked by petitioner for Rajkonda PS, which is near to Tasgiri. Also, there is a serious allegations about the theft of the ornaments.
Nagar to Malta is the one.
There is a threat because the petitioner, kindly see the petition copy, page 10, para 10. For a moment, there is a serious allegation, entire belongings to thefted by me. The allegation is that.
This is contention, sir.
And the allegation is not, there is a,
Already taken that out.
there is a threat of the nearby area.
President of land, Redmet, yesterday, Abdul Banamet. First farmer.
Small.
First farmer.
Also, I registered a 498 case also. Here, Rajkonda PS, on police station.
Paper not, sir, within local city only. Paper not preservation. Post after 4 weeks, on the petition. I will take out concourse of the service.
Item number 13 and 14.
Yes, sir.
Ramakrishna says
After that, please. Your last CRPs by the NSD, opening and part of the given for the purpose of class examination. In fact, the interference was filed on 27/3/2017. Almost 100 adjournments, more than 100 adjournments taken for class examination. Several times conditions were imposed, and none of the conditions were obliged. And earlier also an application, class examination was submitted. Similar applications were filed. 3 commissioners were appointed. And every time the commissioner is appointed, a commissioner, the respondent counsel used to say that I am not going to conduct class examination before a commissioner, he would like to do it before the bench. So similarly, your lordship, after granting several opportunities, your lordship, again, finally, ultimately, the class examination was permitted. Similar applications were filed. We oppose an application stating that we have taken more than 100 adjournments. We cannot be granted graciously, they cannot be given opportunities like this. Therefore, against those applications, you have to be present as CRP has been filed.
Going the rocket attack theory, it says around 7 to 8 adjunctions are on partial dependent. Consider it is PNR, petitioner not ready, PO is on CL, both parties not ready. These are the bracket orders, other lordship, the respondent is 75%. During the COVID, he could not make him the value.
Even the petition is also estimated.
Yes, show me.
10C page 21.
Yes, sir.
11/8/2020, PO is on CL. Lordship, other page 22, Your Lordship. 24, 11, 21 is adjournment taken by Your Lordship. Other and 21, 2, 21, the same date target orders are there. The three adjournments in page 22 are taken by different. Further, Your Lordship, this matter the definition suit, Your Lordship. Whereas, the matter was disputed. Whereas the petitioner being an advocate, harassing the respondent one way or the other. The thing is that the marriage was nullified, divorced, and he's paying child support and everything. But these parents are fighting in court about this. Page 23 also, 28, the adjournment taken by us, 18-4, and 21. I found we can say it in less than 10 years. The statement 100 adjournment is not correct. He was an elder person and the court period was prevailing. He could not make himself available. That's why he has filed a petition. And the law court has tried to allow it.
Page 24.
Yes. Both are absent. IA is pending. IA 123 is pending. IA pending. IA pending. That we cannot present that.
These are the application. He is to file an application, he is to keep the application pending.
If we have filed the application, they have to come forward by calling counter. They haven't filed the counter on time. And the IAs are pending in the docket order shows that the IAs are pending.
I am requesting your lordship witness to fix a time for class examination so that the class examination will be come. I'm not saying that he denied the application. Let him be.
Yes, sir.
Some time limit may be fixed by this.
Yes.
Some time limit may be also fixed for the purpose of this. That both the petitioner and the defendant are the.
That itself the information suit. The information suit is filed based on the counter which is filed in the divorce petition. The allegation filed in the counter of the divorce petition was not when he has filed a defamation suit. Since the petitioner is an advocate, one way or the other, he has filed the suit. The earlier defamation attacks on the person completely defames the person. The person is he has filed document in the court. Based on the
Take it for 70 years age.
yes, sir. 74 years.
Both are serious.
2016, 70 years, sir.
74 years.
Now 74 years.
Yes, sir.
Take it for sir.
Yes, sir.
Petitioner hearing now.
He is a petitioner.
He is a petitioner. Tilla Banka sir is the respondent.
I
And
final.
son, yeah.
Now he's 70 years.
Yes, sir. Now he's 74 years. 73 is written in the TRP.
Bapu has 74 years.
Yes, sir.
This is also 70 years, sir. Advocate.
Both are senior citizens.
It is the problem. Related issue.
The problem. Point number 2 is
Anila is son of the respondent number 1. In matrimonial dispute arises the development of a cross, it is coming up across the respondent.
so you want 10 minutes for the disposal of suit also.
Class examination. Because both are senior
It
citizens.
may not be possible.
Lordship can say as expediency.
Sir. So we are going to the case and disposal of CRP.
The time for class examination.
What was second CRP?
So reopen and recall and reopen.
Okay. I want disposal of court. Disposal. That is the court will do. Completely. Examination within
2 weeks. 2
Huh?
weeks. Right? Within 2 weeks.
4 weeks.
Ready out and
Four. 4 weeks. 4 weeks from the reduction will cover this order. Yes. And after that, dispose of the. Yes, sir. Disposal of.
Direction will also given for disposal of speed.
Yes, sir. Both not disposal of.
Item number 15. Yes, Sandeep Reddy, Veer Masukan, Venkat. Vivekananda Reddy.
What is contempt? Human response.
From 1 to 7. And draw only one page of your.
What is the order for contempt?
Just a moment. By page 22.
Page 20.
22. 22.
Yes, sir.
Clarify line 4 from bottom. Order dated passed in so and so in SOP so and so to purpose is set aside, enabling the petitioner number 1 society to conduct election by way of fresh notification as indicated above. This is the order. 23-page affidavit in contempt. All my life, 1 page, 1.5 page, maximum 2 page contempt. So we'll have to show what is the contempt. 23-page affidavit in contempt. According to him, why there should be contempt, court should presume.
To understand the code, they filed detailed
They should know, court understands only half line, not 23. They
You
should
don't
know
know
that.
that, huh?
It is their understanding.
Yes, sir.
You not see page number 17, 23 pages, paragraph. As per story, court said, this is an SOP of residential society. That has to be maintained, water, electricity, all that, security of each society. So they wanted to have election. These two individuals, they are neither residents, they are defaulters, they never wanted to have an election. They obtained an injunction. We came here in CRP 227. We said, how can we stop election? It has to continue. Court only said, all right, in their presence, enable to, in their presence, it's a consent order. Then they come up with 23 pages. Then now there is one another thing I want to know your lordship. R12 itself.
Sir,
election
if it's standing process, please.
R12 was a returning officer. If they filed a counter and not served purposely counter on me, we are from R1 to R7. He has to do that because it is he made some personal allegations, naming. He was election officer, nothing to do with the building. Advocate, he was brought in to conduct election. So he jumped that group and started making allegation of the what education in this. This residential society, why should we they fight? And why this contempt? Suppose for some reason we go to jail. What will happen? Election still has to continue. No, that's a welfare under society registration. That's a welfare society by all the members. Yes, sir. First thing my submission is like R12 serve notice for me because he made some personal remarks.
With R,
Election officer.
after not filed any counters.
But he has to serve counter on me. And for R1 to R.
Don't ask, sir. R8 to 11, who is the people after 8 to 11? A different story you have?
I'm just the election committee members.
Okay, you're opposing the standard petition?
Yes.
Sir. Who is R1? There is copy of the R1 counter?
Counter served now minutes, page 7. That unnumbered paragraph.
Not put up by the registry, sir. Out of response, part number 12. Who is for petitioner? Yes, sir.
You have reasonable time, but not. Contempt is unnecessary troubling. They are trying to stall election. Welfare society election.
Sir, there is no orders for the contempt. It is pending. Contempt is pending. Yes, where is counter from there? After petition 6 times, post after 4 weeks. Intent is related to put up the counter for the part number 12. Yes, sir. For 4 weeks.
Number 16. Yes, Kiran bhai is here.
Yes.
Your lordships have passed on 25/1/23, directing the tenants to comply with the order within 4 months. So far, they have not complied. Again, after the lapse of time, they issued one more order. Lordships would find it at page number. This is 5.
Melody, it is attained finality, Melody, within 2 or 3 days. We will comply.
Yes, sir.
Melody, we will comply in the order, Melody, within 2 or 3 days, Melody. It is attained finality, Melody, 20th October. this respondent communicated a letter to the officer, my lord, to disburse the amount.
Yes. With the order, sir.
My lord, the terminal benefits may be paid, my lord, within 3 or 4 days, my lord.
Yeah, 4 days. After
Yes,
that, it is copy, no proceedings.
It is attached. Just now I received the UO note, my lord, on 2013, my lord. This respondent issued, my lord. May I read, my lord, this?
Yes, sir.
The terminal benefits of late to S. Pradeep John, lab technician, grade 2, E number so and so request. John Pradeep has been given in a compulsory retirement 5/8/2021 and expired on 12/3/2022 as per the family member certificate issued by the Revenue Department, Government of Telangana. The Amon John and Amon John are the sons of the late S. Pradeep John. The benefits may be paid accordingly. 3 or 4 days time may be granted, my lord, the amount will be paid. As per my oral instructions, my lord, they are also called to the their family member, my lord, to approach the office for the complaint.
Petition name is Gulam Rasool, father of the, I think.
Yes, my lord. Amount is paying to the sons, my lord.
Even petitions only, this was the amount of petitions only. As per the certificate of the.
Yes, my lord. As per the Tahsildar issued family membership certificate.
Tahsildar is issued certificate by you. Where is the certificate? I think he is not filed any certificate. It was Tahsildar, sir, obtained.
Family certificate, we have filed petition, my lord.
Okay.
That is there in the petition.
Cause for the respondent seeks time.
I just make
Implementing within 3 or 4 days. What more you want?
No, I just make one submission, I leave it to your lordships. Your lordships being very kind and
No.
the benefits
Now
last at
Now they are paying one ready to pay amounts.
He's an 82 years old man, my lords. They are making him go pillar to post.
Now they are ready to pay the amount within 3 or 4 days.
Let
One
them
more.
complain, let them
That's
complain,
right.
let them give their
How's
identity
the
to
standing
your
counsel for the
lordships.
respondent? I mean,
They
response are
got
going
yesterday,
to
but
complain. Post it after 2 weeks. Yes, sir.
Obliged, my lord. Obliged.
Next case.
Item number 17, case and you please legal surety.
Yes, sir. And first to start, respondent seeks further time to file count as not for the compliance. After filing, they will call us second time. That is the. Yes. And if you notice, then I have sent a Vokara to the response council.
One accommodation that we
For this matter,
the date of birth was an issue made. Your lordship has applied the date of birth as claimed by the petitioner. He will get a benefit of 4 years. Now the problem with the management is my lord, if they comply with the order, I have told them to comply with the order to reinstate him into service. The problem still would be the wages. He retired in 2020. So these 3 years.
without a issue notice to the respondent, you are already the date of birth, the service regard. That's it, law. You have to issue the service.
Even as a tag end of
You have to pay. You have to pay.
that is bothering him. Otherwise,
Let's set it as basing us.
yes, my lord, your lordship has
Apex school
even
have
though
different
they will be referred to after the also when that is right.
Yes, sir.
I advise them that we will apply your lordship with grant 4 weeks.
Standing goes to the respondent. So it seeks time to comply the order of this court. Most of
Item number 18, you please must not give push
the compliance are not the what are the sections, sir? You have to comply. Others, education in the sections. What is the direction, sir?
I will go to the office. It's often direct responsibility, the appeal of the petitioner related to it, so our strategy direction. Okay.
Yes, sir.
Last. That is submitted as per extract of the parent number of the must 370. After allotment, if this post working under state government, local bodies and state government institution.
Santosh, what is this? Communication worker. Pass on. How will concern? Then order instructions. Letter to the secretary. Huh? Yes, sir. The director, commissioner to secretary. Order instruction to you. Yes, sir. They are you have to consider. Egypt process 1. 6 for the time. Post after 2 weeks.
Item number 19, P. Ravindra Reddy, P. Chandrasekhar Rao.
Yes, sir.
Direction is business are working in. And not that we will not the extended time. I will utilization of operation of the services in terms of Kumar. Earlier on that the claim was rejected. And your lordship settled the rejection of the direction considered in terms of the order is there. Age 15 meters.
So the elections passed by the respondent on 22/9/2023.
Of filing, you do not also decide that director should consider this in terms of again, the present, filing present continuity, again, same grounds, this name was.
Then now the accepted para 53 of the Umadev judgment.
Earlier, Millard, that is there. In the second round of litigation, Millard initially, claim was rejected on the ground. Then you have lordship said that you could also directed to the claim in terms of. Also, yeah, sanction rules cannot be followed from when the government has created, that is the input order. Regarding that Millard, they were also.
So now the given reason, sir. Issue appointment must be done by the competent authority. There must be a sanction post on which daily every employee must be working.
Earlier also same.
The true effect
Earlier
of directions is that all persons who have worked more than 10 years as a 10/4/2006 without production of any demands of any court or tribunal is vacant post. Possessing the individual qualification are entitled to be considered consideration.
Here also same implement. Other those will not go satisfied.
Please. The same petitioners.
Same petitioners, earlier they approached the council. Then they rejected. The kindly page. As per the second paragraph, last but one paragraph. Page 45. Exactly the action. Business of work with. Yeah.
Yes. Now they include that. Now they changed their last 3 paras.
You can change the bullet, but meaning is one and the same bullet.
No.
There is no sanction.
Now there
is no sanction.
clear the petition. It is clear that petitioners have to satisfy the main requirement of the judgment of Umadevi. Then question, sir. Then you have to question, sir.
That is sanction.
No, this, what is my, no, what is presented?
Next week.
Where is this?
I will, with detail, next week, maybe last week.
Third point counter.
Next week, maybe last week.
Second, file counters. Huh? No, they are saying that condition is that there is no orders. Equal. Already basic on orders are continuing on data. That is the.
No material has been found. Not a big blood.
How can content report can be? Think all these things.
There is no such.
Let us have question the same. Even the regions in the. No, in Illinois, I have seen for paper 45. Different agents. Earlier different agents.
Continue on the strength of that is there. Page 45. Is there page 45 in the last paragraph. They were continued on the strength of tribunal orders.
No, now they change it, sir. This appointment must be done by competent authority. And there must be sanction force on which daily annual employee must be working, and true effect of the directions is that all persons who have worked more than 10 years, your person last word, without question of the next year. How much is that? 6 times, post after 3 weeks. Complete cure. Complete cure. Yes.
Services.
Yes, sir.
It's a specific direction from my I should not commercial report of the state. But they have given this office subordinate. That's direction is to reconsider for a judgment. Request some time. Yeah, the different from the election for this.
They are giving to other sub.
I consider that aspect.
In the district, except this petition, they are giving to other candidates in that compact. Because starting that after this cohort, that's why
Yes, sir.
I recall that aspect of them also. I consider to
she's having to doing children relax since 1 year since that.
but my last direction they have to implement.
AGP successful. Takes time to compile our post after 4 weeks, sir. 8-1.
Really, which will not be.
No, sir, actions, there are legal corrections. After 4 weeks, we'll see.
Item number 21. A Venkatam Reddy.
Yes, correct. Madam, complied? They paid 2 lakhs. See what is, yes. Sir, actual direction is to dispose of recommendation. Or the president pass out. Then you question the.
In my representation, these two also there.
Then you have question. Other, very separate recommendation of the. First, turning goes. The article is for the complaint. Then. Wait. About 2,24,654 to the petitioner. Same as article with the cost for appealing by the petitioner. Now the same category goes. Yes.
Item number 22. M. Srinivasa.
To reconsider the case of the petitioner for allotting an existing vacancy of secretary grade teacher in Rangareddy district within 8 weeks from the date of this order.
Juniors also given the same Bangladesh allotment. Very successful. 6 time. Post after 4 weeks for compliance.
Item 23 agent, item number 24, Sujit Jaiswal, G. Pawan Kumar.
File the counter. What is ready?
Yes, I have seen that. But also, that's why you are very true. You are also. Yes. Sometimes for 6 times. Post after 4 weeks.
Item number 25, TS Krishna Prasad, Adi Venkateshwar.
That's what I was GP. You got that GP plus. On both sides. Post after 4 weeks.
Item number 26 to 33. Ravinder.
What happened?
And with my arguments, my lord.
Last time, right? Agenda matter last time before vacation.
For reply arguments. Yes.
For reply the agenda for.
But it's 3 days happening the same.
They don't want to Friday. When will you appointment with? Their council. Only Tuesday.
Tuesday. Tuesday.
Not this Tuesday, sir. They're given time for only 2 or 3 days for Telangana. That's why I asked.
Nothing. And be like it when they indefinite
Yes,
stay
sir.
in this case. Otherwise, next.
Also, petitioner 6 time. Post on. 21st.
Not any shorter date, my lord,
21st, sir. Next week only. Tuesday week only, sir. I posted. Tuesday week.
Item number 34 and 35. Hariprasad, Ravinder Krishna.
Lordship, I am on through online Lordship. I request 1 week time Lordship in this. I could not because of the throat infection. I'm for the petitioner Lordship. Lords, I filed receiving document petition also Lordship. IA2.
Yes, sir. Here you.
I have it next week Lordship.
2 weeks. Sir. Next week's time. Post after.
Lordship.
I had to have some papers on the side, sir.
I served Lordship already. Receiving document petition I served and numbered also.
You will make, sir. So you will hear you.
No, I didn't receive that. Is what I'm saying.
Yes. Not show your paper. Verify the clerk, sir. Your papers for more.
I'll serve. I'll get served. Welcome.
Post after 2 weeks. Copy is read. So copies to respond. Respondent. No.
Item number 36, it is on yes, Nagesh Reddy, Kiran Kumar, Honorable Kiran.
I think before vacation matter.
Yes, no, yes.
At length, but for an all these things. Almost 1 month over. Possible. Response C. You are also right. You are completed your arguments. Okay, it is most sets. Most out of 3 weeks.
Item number 38, come on the. So let's do this number.
Gross copy of the bill. Police station contest are given, there is no detail, rest are in the police station. Filing of my counter before the court matter, they have filed reply to reply. Because they filed my counter, I filed reply. Yes, now they filed, thereafter, they filed reply to reply about it, before the court along with some. What are the documents? Relevant or irrelevant? They want to say, my lord, before this unquote, they find documents saying that the question was the foundation of the will. Will is exhibited in the year 1982. First time in the year 2014, the will had come in the picture, saying that what the will is lost, that is the foundation according to them. I argued the matter saying that you issued a legal notice in the year 2009, wherein you said that two brothers are having right in the property, sisters are given gold at the time of marriage. They further filed a caveat wherein there is no difference of will in 2009. USA declaration was given, there is no declaration of will, all legal rights are entitled, all these documents are there. Even in the counter affidavit or reply to reply affidavit, that is no reply to these facts. Now they are coming saying that land was acquired by the government. In the acquisition proceedings, respondent number 1 has received the entire compensation. Therefore, the foundation is laid. This fact was cleared by the plaintiff itself that he has misrepresented the authorities and taken the entire amount and assured that he will pay the amount. This plea was taken by me in the plaintiff itself. We were way back in the year 2014. No matter, even in the document filed by them, one of the document, page number 11, which says that with reference to above, Mr. Karunakar submitting. What is dated? This is the index, running index, recently filed, dated 29/9/2023. 29/9. Let's make the because when a memo is there, statement. That's sir. IA2 writing in the index. Page number, sir? This document filed by them, one is the start page number 7. Letter of JHMC. At Greater Hyderabad, a letter issued by the TSHC, my lord. Yes. To the, this is respondent number 1. And then, my lord, take this page number 11. In the entire letter, in the entire correspondence, there is no reference of will. The case is that in the pleading itself that he has misrepresented authorities and took the entire amount as he is the only heir of the decision. Here, my lord, page number 11. Yes, sir. Our reference letter dated so and so. We reference with reference to the above. I, Mr. Karunakar, submitting legal aid certificate as advised by yourself regarding where is the legal aid certificate? It is not filed before this court. He has filed this letter before the court saying that I have submitted legal aid certificate. There is no such legal aid certificate filed before the court. In what way that legal certificate being issued filed by them? Yes, my case is that he has misrepresented the authority. What is this CRP? Are you arguing with entire suit here? These documents are beyond the scope of the CRP suit. Then I will say all these things. These documents are not filed in the lower court.
Lordship, if I may, because I actually have argued first and then my learned friend would have responded. Last occasion, my learned friend said, what is
petition of CRP, sir. He is a petition of CRP.
With respect to the IA, your lordship.
Not IA, sir. CRP, we are saying the CRP was separate IA, not hearing separate IA.
With respect to the CRP, he's examining my documents.
Yes, sir. He is right to examine his documents.
One small reply to my learned friend's submission is, he says that we have not whispered about the will. No conduct of ours is there as far as claiming ownership of the right of the property is concerned in a sole manner. Now we show proof of claiming ownership on a sole manner. He now says that no, that is not good enough. This should talk about the will also. He can ask all of these questions. In fact, more 10 questions in cross-examination. Court has left it open in the order that this is subject always to the relevancy as far as the cross-examination is concerned. Lordship may see the impugned order. I will read it again, just the last 2 lines. Lordship may come to page number 11, the CRP. Sorry, Your Lordship, page number 10. Point number 5.
In regard to the both said contention as seen from the record, to clear that both parties to the suit are family members of late K. Malappa. The suit being one for partition as separate position. All the disputed facts, the jointness of the property or its severance, the existence of so-called will dated zones, and so as to its forgery, fabrication, and the fact as to losing lost of so-called will in transit can be decided only after a full-fledged trial. It is the propounder of the will to prove it beyond doubt. Is not relinquished my responsibility for proving it beyond reasonable doubt. He still kept the liability on me. It's further seen from the written statement of the defendant that there is a mention about the fact of the will being lost. There is also mention that on a police complaint in that regard, the police Humayun Nagar have also given a certificate that in spite of best efforts, they are unable to trace out the lost document. Hence, as foundation is laid in the pleadings, there is no impediment in permitting the party to produce secondary evidence. It will be tested. Now, let us look at their claim, their own claim. Lordship may come to page number 22. Para number 4, page 24, internal page number 24. Para 4, the plaintiff submitted recently defendant number 1, disbanded 1 shed and 7 sheds are in possession of different tenants from last 10 years. And the development of the said property was made out of the rental income received from the tenants. Now he's admitting that my possession is there, I'm exercising power over the property. The defendant number 1 and 2 are collecting rents to the tune of more than rupees 1 lakh per month from the tenants, and no share in the rental income is being given to the plaintiffs here, in spite of several requests made by them from time to time. The plaintiff submitted during the year 2009, road widening was also affected, and an area of 469 so-and-so square yards was affected in the road widening. The compensation of 30 lakhs was received by the defendant number 1, misrepresenting the Commissioner TSHC that he is the only legal heir of the deceased K. Malappa. Now, your Lordship may come back to the document, in my document that has been submitted, page number 11 of this ID number 2, your Lordship, where he says, I misrepresented, your Lordship. Page 11, your Lordship, the correspondence with GHMC Commissioner, your Lordship. With reference to the above, Mr. Karunakar, submitting legal heir certificate as advised by yourself. I didn't submit it on my own. He asked me for it and then I filed it, your Lordship. Now, your Lordship may come back to the claim, your Lordship. In para number 5. I complete, sir. I didn't interrupt your Lordship. You asked for will be produced. Now,
please give answer to courts and answer there.
He's interrupting you. Para 5. THMC that he is the only legal heir of deceased K. Malappa. It is submitted that when the plaintiff's question to the defendant about the same, the defendant assured that the plaintiffs and the other defendants that he will pay the amount of their share as the amount received from the corporation is already invested by him. No proof of all of this. However, in view of the relationship between the parties and the plaintiff's belief, the defendant of 1 and his assurance. However, the plaintiffs called upon the defendants to partition the entire property into 7 separate shares, enabling the plaintiffs to have their separate shares over the property. Last occasion when we were arguing this matter, I distinctly remember that my learned friend's submission was that if you were the owner of the property by virtue of will being given to you as the sole owner, did you ever exercise ownership as a sole owner? His own claim shows that I have exercised ownership as a sole owner. Might be a case where he thinks there is a contradiction as far as the exercise of sole ownership is concerned. But in a 287 petition, where the current judge has already given him validity to question all of this, to say that this has to be decided at this stage is immaterial. He's again and again asking. First, he asked to show the proof of will. We filed a police certificate. Then he says, okay, you filed police complaint. Okay, not a police complaint. At least you should show me when and where did you exercise full ownership. It is not just that I was exercising possession over the property. The government also recognized my right and gave me compensation. It is not that it happened in a day, Your Lordship. It is a period of time when land acquisition proceedings take place. At that point of time, he kept quiet, Your Lordship. If at all there is any problem with my will, in my cross-examination, I will fail, Your Lordship. At this stage, when already there has been a substantiation as to when the will was lost, 65 sub-clause C is very clear. Your Lordship may just look at 65C. We are going into over and beyond into any scope which is required for the petitioner to stage. 65.
Yes.
Cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition, or contents of the document in the following cases. See here, when the original has been destroyed or lost, or when the party offering evidence of its content cannot, for any other reason, not arising from his own default or neglect, produce it in reasonable time. Nowhere in the section it says that I have to establish a prior ownership, a prior execution with respect to ownership, exercising ownership. Section just says that if I am able to establish because of no fault of my own, I have lost the original, that original may be adduced as secondary evidence. First time when I argued this matter, I said, Your Lordship, that marking is entirely different from admissibility, processing, and reliance on the document by the concerned judge. Yes. It is his discretion. If he has a problem in the final proceedings, where the judge gives a judgment, probably, if at all, I'm fortunate in my favor or in his favor, parties can question the reasoning, Your Lordship. Wherein does the provision even state all of this, that we have to show that we have exercised ownership, and now that he admits that we have exercised ownership in his own claim, now I have to rebut that in a CRP, Your Lordship, where I produce evidence. He has a problem with me giving a reply to reply. For marking of document, he asks 10 replies, which he can ask in a cross-examination, Your Lordship. That latest Supreme Court judgment, I will just read it once, Your Lordship. I piloted the memo also, Your Lordship. Last line will be, Your Lordship. This is of 2016, Your Lordship.
One minute. So, yeah?
2016.
Yes, sir.
Paragraph. It is well settled that if a party wishes to lead secondary evidence, the court is obliged to examine the probative value of the document produced in court or their contents and decide the question of admissibility of a document's secondary evidence. At the time, the party has laid down the factual foundation to establish the right to take secondary evidence, where the original document cannot be produced. It is equally well settled that neither mere admission of a document in evidence amounts to its proof, nor mere making of exhibit of a document dispenses with its proof, which is otherwise relied to be done in accordance with law. 23. In the case of so-and-so, consider requirement of 65 of Evidence Act, we do not agree with the reasoning of the High Court. It is true that a party who wishes to rely upon a document, contents of the document, must produce primary evidence of the contents, and only in exceptional cases will secondary evidence be admissible. However, if secondary evidence is admissible, it may be adduced in any form in which it may be available, whether by production of a copy, duplicate copy, by oral evidence. Now, assuming I don't even have the police stuff, I get 2 witnesses to say that there is this will that was executed. For some reason, we could not have produced a police complaint because at that time there was a death in the family, or I had a business crisis, and these witnesses proved to the fact that this will was executed. So even oral evidence is there. The secondary evidence must be authenticated by foundational evidence that the alleged copy is in fact a true copy of the original. Even the oral evidence can be a true copy of the original. It should be emphasized that the exceptions to the rule requiring primary evidence are designed to provide relief in a case where a party is genuinely unable to produce the original through no fault of the party. I will, before moving to paragraph number 24, I would also like to highlight that under what provision are we standing before this court? We are standing under 227 by a long shot, also 115 as far as CP is concerned. Now, Your Lordship, the trial court has not decided merits for an appeal to be maintained with the Lordship. That is why we come under revision. This honorable court has power to revise any such conduct of a lower court or any subsidiary subordinate body if there is any such violation of procedure. In 227, where there has been no violation of procedure, can a discretion of a judge be reviewed to such an extent that we are analyzing evidence of every stage? In fact, the very purpose of trial being conducted goes away under 227. This court starts questioning the discretion of the judge. If the judge maybe would have interpreted 265 of the Evidence Act wrongly, or would have commented on the merits, then an appeal would have been filed here. Just a small academic discourse from this. With most lawyers, whenever there is a submission, they try to file a CRP or a CMA, and Your Lordship, the other time when I was appearing, I said maybe this was filed as a CMA, and Your Lordship said, no, this court said that CRPs are rightful provision and it should be converted to CRP. The difference between the both is that under 41 and 43 of CPC, even otherwise, when a trial court is deciding merits and liabilities of a matter, then it is an appealable order. When a trial court is conducted an error on record, then it's a revisable order. Is there an error on record as far as this is concerned? Is there an error on record as far as
Continue.
24 years?
And board of more than 200 cases, but
Yes.
continue
After
the case.
considering the
Stop
entire
that.
facts of the case, last paragraph,
Yes.
last one. Considering the entire facts of the case, the evidence adduced by the appellant for the purpose of admission of secondary evidence, we have the view that all efforts to be taken for the purpose of leading secondary evidence. The trial court is noticing that the photocopy of exhibit so came from the custody of Solis Cluster, who brought on record has been examined as a witness. I will be examined as a witness. In view of the matter, there is a compliance of provisions of section 65B and visible that cannot be on ground to reject the secondary evidence. In our view, the trial court correctly appreciated the efforts taken by the appellant for the purpose of leading secondary evidence. For the reasons aforesaid, the impugn order passed by the High Court cannot be sustained. Appeal is accordingly allowed. Last, 26th paragraph is very important. However, we make it clear that mere admission of secondary evidence does not amount to its proof. Your Lordship, I have a theory which I can do. My
Not
Lord,
theory, sir. There are straight away.
because he keeps on putting theories. What if his witnesses answer in my favor in cross-examination and admit to my will? He's assuming that I am the one lying. Cross-examining his witnesses, they admit to the will. The case is gone, Your Lordship. He's assuming that I am a liar. He's assuming I have created a will. What is there a problem if I cross-examine his witnesses with respect to the will? And they say that yes, this has been executed. The genuineness, correctness, and existence of documents shall have to be established during trial, and a trial court shall record the reasons before relying on those secondary. The trial court has still not recorded the reasons for relying on the document, left it open for it to be tested. Now he wants those reasons to be tested in a CRPL.
Yes, sir. Yes, sir.
I'll take only 2 minutes.
Yes.
The judgment which is referred by my friend is a matter wherein the original will was lost by the DO Ambala. It was submitted there, it was lost there. So when the document has come from that custody, the court has considered that genuinely it has Xerox has come, it is to be even then, when it has come from the custody of the DO Ambala, even then the court has made some observations around number 26. Here is a case, my lord, wherein the document, according to them, first time they said 2014, admittedly, first time they said in the year 2014, this document, Xerox copy is there, Xerox copy is lost. But I have already submitted the citation of Supreme Court before this court, wherein it categorically said the secondary evidence relating to contents of document is inadmissible until the non-production of the original document is over. The court has made it very, I have already passed on judgment, Marat. This is 2011 4 Supreme Court, Marat, as I have filed. The provision of section 65. 1872 Act provides for permitting the parties to adduce secondary evidence. However, such a course is subject to a large number of limitations in the case where the original documents are not produced any time, nor has been factual foundation has been laid for giving secondary evidence. It is not permissible for the court to allow party to adduce secondary evidence. Thus, secondary evidence relating to the contents of the document is inadmissible until the non-production of the original. Here, Marat, it is nowhere as per this kind of this para, Marat. It is a case directly related to our case. In case where the original documents are not produced at any time, nor has been factual foundation been laid for giving secondary evidence. And this fact is particularly connected to the facts of present case. Nowhere it is produced. Yes. And provided for the section, this secondary evidence must be authenticated by the foundational evidence that the alleged copy is in fact a true copy of the original. Here, admission of document in evidence does not amount to its proof. Therefore, the document evidence is required to prove in accordance with law. The court has come to the conclusion that perhaps secondary evidence is not permissible in case original is not able to compare with the original. And the foundation is not being put with regard to the document. And also relied on Marat Supreme Court, another judgment just went before this court, Marat. 2007 Supreme Court, Marat. 2007. May I pass another bill?
Only one copy. One is Akesh Mohindra versus Anta Bedi, filed by the respondent counsel. Give one more copy. Yes, sir.
There are 7. Secondary evidence is a general rule is admissible only in absence of primary evidence. If the original itself is found to be inadmissible through failure of the party who finds it to prove it to be valid, the same party is not entitled to introduce secondary evidence of its content. Essentially, secondary evidence is an evidence which may be given in the absence of that better evidence which law requires to be given first when a proper explanation in the absence is given. The definition of section 63 is exhaustive as the section declares that the secondary evidence means and includes and then follow the 5 kinds of secondary evidence. The rule which is the most universal, namely that the best evidence in the nature of cases will admit shall be produced. Besides this objection, that rule only means that so long as the higher or the superior of the evidence is within your position or may be reached by you shall give no inferior proof in relation to it. Section 65 deals with the proof of produced secondary evidence. It is necessary for the party to prove existence and execution of the original document. Under section 64 of documents are to be proved by primary evidence. Section 65, however, permits secondary evidence to be given of the existence, conditions, or contents of documents under the circumstances mentioned. The condition laid down in the said section must be fulfilled before secondary evidence can be admitted. Secondary evidence of the contents of the document cannot be admitted without non-production of the original first. Counted for in as such manner as to be bring within one or the other case provided for the section in Ashok Dulichan matters also. Unless the matter original is not produced, the secondary evidence cannot be considered. After in this matter, the reference is given Ashok Dulichan matter, and conclusion is there. There is also another material on the for the field to explain whatever circumstances under which the footstep copy was prepared and who was in possession of the original document at the time of photograph were taken. The admitted facts in the present case are that the original was with P. Srinivas Rao only when the conditions of section 65 are satisfied, documents can be admitted as secondary evidence. In the instant case, section 65A has been not satisfied, therefore the High Court order does not suffer from any impunity and warrant interference. In this case, the court has particularly referred with regard to Ashok Dulichan matter. Secondary evidence of the contents of document cannot be admitted without non-production of the original being first accounted for such a manner as being within the one or the other cases. Here is the case, the original, according to their own case, they have lost the original. I think it's on record to show that original is being lost or not, because the police complaint as given by them is not content with regard to the bill. They say original document lost. I categorically said before the court, even pleadings are there, the original document is in the custody of the plaintiff before the court. They are the sisters. In the plain development is that defendant number 1 and 2 brothers are collecting the rent, not defendant number 1 alone. He is claiming ownership alone. I said in the pleading that defendant number 1 and 2 are collecting the rent, they are not giving the rent to the sisters, not accounting for to the sisters. So therefore the parties should be filed against brothers and other sisters who are not joining the plaintiff. So it's a case wherein parties should be sought. The bill was not referred anywhere. First time 2014 saying original is lost, because once the original is produced before the court, it will be proved that it is not a genuine document. And the most important aspect is that the Xerox copy is filed before the Supreme Court. Stamp paper is purchased by one Ashok Kumar. And I also said before the Supreme Court, wherein it is mentioned that all the daughters are married. In the year 82, daughters were minor. So these facts clearly show that they only want to, for other purposes, photo state copy want before the Supreme Court to avoid the original and to knowing fully well that it's created now. Foundation is must, but without foundation, without knowing the original, comparing with the original, Xerox cannot be considered at all. Even opportunity shall not be given to prove in what way it will be proved. The original is not there.
Yes. That's all. You're not sure. Here come both sides for the post orders.
You're not sure buying submission.
Sorry, sir. You have no reply to reply. Sorry, sorry. Yes, after 3 weeks.
Agenda item number 40. Sandeep Kumar.
Yes, sir.
My lord, sir, for respondent, my lord, I may be permitted to appear virtually.
Yes, sir. Councillor, please stand. Post after 3 weeks.
My lords may say 2 weeks, my lord, instead of 3 weeks.
Yes, for 1 week, makes no difference.
Well,
Item number 41G, Susan Reddy.
Please,
Nature.
please, madam. Petitioner. Petitioner is the different number 4 in the court, madam, court below. Counsel for respondent,
Not up to
absent for many times. The last occasion, as my lord was pleased to adjourn the matter on the sense of the. Habits of saying that the stay is until further notice.
Already, yes, sir.
Yes, sir. Please wait for until further notice.
Post for file, yes, sir. Post for file hearing. You are for the
Petitioners.
no.
Defendant in the suit. Defendant.
Oh, that's
Was
what-
set ex parte. Was set ex parte. Filed an application to set aside along with the written statement. That IA was dismissed. Non-appearance.
That way this code. Means, yeah,
Yes.
decree.
Yes.
The respondent. Post for file hearing. After 3 weeks.
Thank you. Actions.
You are busy, or
My
respondent
colleague, senior colleague is contesting.
Okay. Post after 4 weeks.
Thank you.
Item number 42, Mr. Cookie.
Yes.
CRP's filed for, the suit is filed for perpetual injunction.
And who is for respondent?
For the petitioner.
No. Those are not served to respondents or not?
Yes, no.
Professor is quite happy. For it directly to take out professor to respondent. What happened?
Notice has been served.
Is the professor is. So only consider respondent. What about petitioner? Respondent, madam? Then cause for petitioner permitted to take out from respondents as well as the cause appearing by the respondent for below. Take notes only respondent, cause for respondent. What about respondent? Then that is the cause service, madam. And only to cause for the respondent only. What about respondent? So we don't know. As a cause is about
The court below,
first you have to serve. First the respondent also. The party. Advocates have no interest in power. What have to approach the advocate? First for the petitioner. Order to take out personal respondents, call service. Post after 4 weeks.
2 weeks, my lord.
4 weeks, madam. After return
The,
time.
will be completed or not?
Don't know, madam. Not complete after this court. In the month of August, this court directed to someone to respondent. Not for complete orders. Then, call next case.
2 weeks, my lord.
Sorry.
Item number 43, K. Ravinder.
You are knowing about this matter. Cost of petition for SPC. Right. Post after 4 weeks. Yes.
Item number 44, E. Venugopal. It was filed for appointment of commissioner below the rank of assistant director for identification of the property. The suit, there is dispute as to identity of the property. They claim that the property is in survey number 216, whereas we claim that the property is in survey number 215. Lord, the commissioner was appointed earlier, but somehow he did not completely, he could not execute his warrant completely. These three commissioners were appointed, and all of them returned the warrant. Then Lord, ultimately the transport passed this order, issued order, which is on page 8, saying that the suit is for injunction and the scope is very limited. The commissioner cannot be appointed for localization and possession of the property. Actually, that is not what was sought for. In fact, Lord, my land also filed another IA for appointment of commissioner.
And we also want the land to be surveyed and surveyed. They are instead of cooperating, that the commissioners vexed with their attitude, they return the warrant. 3 times, man. There is absolutely no cooperation.
My submission is assistant director has sought for in the prayer. Assistant director may be appointed as commissioner and some time may be fixed.
Yes, sir.
Yes, ma'am. We are very much ready for not shipping. They prevented us from when the surveyor wanted.
Don't go into the case, yes, sir. Don't go into the case. CRP disposal.
Assistant directors.
Both causes appearing for the. This is correct. No objection for appointing commissioner to conducting survey.
Your Lordship may see the prayer is on page 14.
Not below rank of assistant director, surveyors in land records, Sangara district, to localize, demarcate and No offer of petitioner. 1006 time, post after 4 weeks.
In this matter, I am also starting. The vacate stay petition, way back in March. Instructions are that they have obtained the interim orders from this house. They to comply with the condition. The interim order was passed for a moment, the workshops may take up the interim order. The interim order was passed, and their application made way back in the month of November this year.
Subject to condition of the petitioner paying 20% of the areas of rent, excluding enhancement of 20% for every year, 3 years block period with a period of 2 weeks from today.
That order is not complied.
There is no interim orders in the existence. Condition not applied, there is no interim orders. But we will have vacate petition taken into account.
But the fact is that, basing on this order, the court below is not proceeding with the trial.
File a memo, sir. File a memo, sir. There is no exception of interim orders. Then they are not complied.
They are not proceeding. The court is saying that there is a stay order from the Honorable High Court. May not pass any clarification order.
There is no clarification, sir. How can we can educate the officer? Where the question? File petition. There is no interim orders. If they are not complied, there is no interim orders.
Move the petition also and memo.
Then question.
They are not participating.
File a separate petition, sir. Not in the CRP. Whether they are giving clarification authorities.
No, before the court below, we have stated, we have moved a memo also stating that they have not complied as this.
Then inaction file separate CRP, sir. Not by this. There is no orders for vacating.
My humble request, anyhow, they admit, let them show that they have complied the order.
Sir, they apply interim orders with some conditions. They are not complied. Then there is no interim orders. Subject to condition. Interim orders is possible only subject to condition only.
But the court below is all the proceedings.
Then file a petition, separate petition. Conference part petition 610. Petition 610 post after 4 weeks.
Next week it may post it. No, sir. Next week,
No,
2 weeks.
No,
After
sir.
a long time, it is listed. Next.
Yes, sir. This be listed, sir. Each and every case.
Item number 40, Commission.
Yes, sir. What is your prayer, sir? What is your last 3 times you are taking time?
This is distinction between order 9.7 and order 9.13 matter. Even if they have filed this order 9.13.
Okay, here after 4 weeks, common petition 6 after 4 weeks.
Item number 48 is resolution of
Yes, madam. I will leave with both of you. Commercial court. Matter.
Be ready, Your Lordship.
1 year after 2 weeks, madam. Today the number of cases listed. More than 200.
The stay is being granted and it is only affecting the low court petition that is pending, Your Lordship.
2 weeks, madam. Over 6 after 2 weeks. You are the expert till then. For this case earlier, dismissal that case.
Yes. Earlier, based upon agreement of sale, he filed a claim petition. That was.
Yes, he is on virtual mode. Yes, it was problem for virtual. It was problem in the ready to come physically, sir. Problem for your network. Competition post after 3 weeks.
Item number 50, J. Suresh Babu, please read first.
Yes, sir.
Once the expiry of right, this was around expecting the definitely all the
Departure in favor. Post for the respondent seeks time post after 3 weeks. 3 weeks, sir. We'll see after 3 weeks.
Item number 51,
Other than advance done in last occasion, I have seen.
You may kindly take up next Thursday.
Our departure in favor of the order, sir. Madam, you are representing? You have a petitioner?
Yes.
The respondents? Then who, madam? Tarasangi, dear Lalita Gayatri? Okay, with you. Okay.
Permit me to appear once again, Lord?
Nalin Kumar is appearing, he requested.
Yes, sir. Yes, madam. It is taking time.
Yes, Manoj. Lordship may say 4 weeks, Manoj.
Demands granted earlier extended, and the person already last time is there. Also, petitioner seeks time post after 4 weeks of file hearing.
Very well.
Item number 52, Ashok Reddy Kankara.
For the petitioner.
Yes, sir.
We are ready, my lord.
Who is the respondent?
My lord, one file any vatal. We have carried out personal notice to both respondent and to the respondent counsel in the daily court. This was served on the respondent and the notice on the counsel of the record came as unclaimed.
What is CRP?
The CRP is in regard to IA 1037 of 2021, my lord, past file of 8th Junior Civil Court against the order 15A petition. The petitioner is the plaintiff who filed recovery of arrears, eviction suit, and along with the recovery of arrears of rent. And he, when the suit is pending for adjudication, he filed this present IA. The same was the respondent filed counter stating that he denying the judicial relationship between the owner and tenant, my lord. Only based on that ground, honorable judge in the civil court has dismissed this present application, my lord. Permission to circulate this Supreme Court judgment, my lord.
The petition of 15A.
Yes, my lord.
What are the conditions 15A? 15A?
For depositing of rent.
Read it 15A, sir.
The court shall hold the first case management hearing not less than 4 weeks from the date of filing of affidavit.
No, sir, that is not the amendment. Separate amendment is there. First, you got the 15A for AP amendment. Undisputed amounts only permitted. No, sir, they are not denying your ownership also.
My lord, kindly come to exhibit 338, my lord, page number page number 28 of the CRP petition. In that, they have filed one suit, OS 474 of 2021, suit for perpetual injunction. In that, they themselves agreed that they are the tenants of the defendant below. Now, in the another suit, they are completely taking the dual relationship between the owner and tenant.
This is a part, not part of the record only.
It is
Correct.
marked. It is marked. It is marked as a document is marked. Come to page number 9.
Page 21, sir, page 21. Documents, not by the court below.
Come to page number 9. That is another IA application that is for temporary injunction. This is for 15A for depositing of arrears of rent. Kindly come to page number 9. The document is marked for the petitioner. Honorable, the serial number 8, certified copy of claim in OS 474 of 2021 and the file of this honorable court filed by the respondent hearing, which is at page number 28 in this civil division petition by law. Page number 20.
Yes.
In this, para number 3, that the plaintiff is tenant of the defendant in the respect of all the 3 shops bearing number 20-4-25 to 28, totally administered 2,500 square feet situated at Panch Mohalla opposite to New Bus Stand, Charminar, Hyderabad. They themselves agreed in their suit, which was filed against us for perpetual injunction, that they are the tenants. And in caveat also, my lord, you come to kindly come to page number 70. This was the caveat filed by the respondent here in the CRP. In that also they filed that the petitioner is the tenant of the respondent in respect of the all.
Sir, read one second, page 28, first para, third para.
The plaintiff is tenant of the defendant 1 in respect of
the petitioner. Who is the petitioner?
My lord, this is the suit filed by the respondent.
1 minute, sir. Who is the petitioner here in plaintiff in the present suit?
Son of the defendant 1, my lord.
Specifically mentioned that the plaintiff is tenant of the defendant number 1. Who is the defendant number 1? Jafar bin Burman as so now the owner of the property then.
My lord, but the first defendant is no more, my lord. We have death certificate also, and he is the legal heir of the.
But I will hear you, sir, after 3 weeks.
My lord, any short time will be granted, my lord, instead of 3 weeks.
2 weeks. Okay. No response. No. Wait. Part of the notice. No response. For 2 weeks.
Item number 53, please, and you.
Proof of service to them.
Post for petition 6 and post after 3 weeks.
Item number 54, Muhammad Riyaz Ansari, Hamdesh Shukran.
They were already heard on the last occasion. It is coming up only for them to give a citation, which they brought, which they are relying on. Also, may I kindly recollect is that summary suit where trial court having a liberty asked them to deposit the security amount. They are saying that there is no provision as such which wherein the trial court could have granted them the liberty to ask them to deposit the security amount.
Yes, some another person argued with one of the petition. Yes, sir.
So senior counsel is facing some difficulty and some weakness for that at least 2 weeks can be granted.
So again and again taking time.
No, the last time they argued, but I doesn't matter, huh?
It is coming up only for them to submit a citation.
Yes,
Arguments
sir.
are all completed.
But we read some books only without any citation. That's why it doesn't matter.
2 weeks. In submit the citation, if it is posted day after tomorrow.
No, sir, we'll not like you. Huh? Comes for the petitioner. That's sir. Petition 6 times. Post after 3 weeks.
Your lordship is not in 3 weeks. The reason is your lordship as your lordship, the business runs on
Yes,
rotation of money. And if this money is stuck, and that is the reason the business is also getting affected of the respondent. Yeah, your
Yes,
lordship is 2 weeks.
2 weeks, okay, 2 weeks.
Item number 55, Shams Agarwal, GM Dalkumar.
Yes, sir.
My morning respondent also.
Try to know.
Yes.
First one, what else?
Because he is present to so that's why he asked for time. And we have it on Tuesday.
Post for the respondent 6 and post after 2 weeks.
This
2 weeks, sir.
Item number 56, Sarat Kalyan.
Just week time.
First for the 6 times, post after 2 weeks, till then.
Item number 57, L stated.
Yes.
Proof of service file action by Joseph number 81172.
Sir.
28/2020.
CRP?
CRP regards to lordship suit is filed by the defendant partition suit, and we are defendant number 10 as the subsequent purchases. And we are set as expert here, as well as we prepared an IA. To set aside the expert here, to IA number 266 of 21, and it was same as a road and the conditions led to file a witness statement on 4.9. And mostly the general master not condition to report the same order. As such, there is a delay of filing of written statement. And moreover, as a ADD does not appear in the ADD, also the IA does not fix the IA.
Sir, you have not filed any petition section at the time before the court below?
No.
Then they have to file the CRP, where is the file the CRP? There is asking for revising the orders.
Present the orders
The only document that have filed petition to extend the time. Not filing any petition before the court below, they will file CRP.
After the filing of the review, written statement is undergone explicitly not ability to take the statement as it is IA is which forbid not filing of the written statement. IA stands dismissed.
No court to file, having considered the cause mentioned, having considered the objection of respondent plaintiff, the petition allowed by setting the expert order in the detail with the condition to file written statement before time. Failing which the petition stands dismissed.
Yes, sir.
There is a condition order.
Yes, sir.
May action, but for the action time. The question questioning the same. What is wrong in this order? Really, what is the orders in the CRP, sir? The question, which order is the question? What is the revising the orders? That's only. Docket orders. You have to file a petition before the court below, sir, for a session of time.
Staying in the order of receiving the 25 pens and appeared and filed the written statement. Express inability to receive the written statement.
Read 1 second, page number 11 order, docket order.
Yes, sir.
Condition order, this is condition order.
But for not filling of the condition, lordship.
You not file a petition to extend the time, sir. They are given 15 days time. For that means 15 days time. You have petition to extend the time. Without filing any not filing any petition to court below.
The president also the officer was not present. Mr. filed a petition on 24/1/23.
Without petition, what is the order then? Show me.
Only written statement. 24/1/23.
So asking for time, extension of time. File CRP here. How can I file CRP, sir? What is the wrong order? This order. Where is the question? Revising the order.
Revising order the stands dismissed for non-banana with the forfeit filing of written statement.
What is the age?
79 years.
What are the reasons you have stated in your discount?
Because I was stated that also as a age for the senior citizen is not available in the unit course and does not report the same condition. And the appearance of the 22 and the 25.
How can you throw the on the advocate, sir?
No.
Before the council, you are the.
In spite of the previous days.
Wait, update. I update. Wait, update.
In spite of the preceding dates of the people did not leave lots. As such, could not make any IA details.
You can file inward also. Where the question? Not any. Not for any IA also in this matter. Where the update, sir? Not for the update also. Simply saying that program is the council. What is his name? Not mentioned anyway. Post after 4 weeks.
2 weeks.
4 weeks, sir. Not appearing for last quarter. The supposed to discuss the last occasion. And not coming. That was the urgency for you.
Item number 58. J. Narendra.
Yes, sir. Corporate 6 time. Post after 2 weeks.
Item number 59. NHIGHCOURT Rohit.
This is good matter. We did the increment. Yes, sir. There are both sides. Post this matter for final hearing after 6 weeks.
Item number 16.
The learned trial judge has posted the matter with judgment. Therefore, the matter has to be heard. The learned CM was right here. The matter is judicial worked out. That is not fair practice.
No. How can we say that? No.
He was sitting here just 2 minutes back.
Wait. 1 minute, madam. Don't give answers to. No, sir. No, sir. He is senior. Our court is. You don't know.
Let us say which court is appealing.
What way? No, not necessary for this court, sir. All these things. Not way. Post after 4 weeks. Sorry, sir. Post after 4 weeks.
The matter is posted for judgment, my lord.
Nothing will happen.
The matter is posted for judgment. I will deprive of my right.
Is it post for all these intimations there? Continue.
My humble submission is kindly take up the matter. Let the matter be passed.
No, sir. No condition order, sir. This court
The matter is posted for judgment, my lords.
What happened, sir?
The matter is posted for judgment to the learned trial judge.
You
If the
continue,
Supreme
sir.
Court does not take up the matter today,
No, sir.
but incalculable time will be cost to me.
You are saying something, so many things. We'll hear after.
My lord, he has
Post is for after with the other court. There is not a party.
Item number 60.
Not this matter. There is another connected matter here, 11 of 2023. Not this matter. In fact, this Advocate Commissioner, the plaintiffs, the petitioners of the plaintiffs filed a suit before the arrest for cancellation of urgent sale dates law. Pending suit file an application for appointment for Advocate Commissioner to take marking of the documents in cross-examination. That was petition was dismissed. Project for and another matter is also there. CRP 1162 of 2023. Another pin 1162 of 2023. 762, sir, 2023. This matter posted for dismissal last occasion. No. That because the lawsuit directed to serve notice to the council because they are not receiving notice. But I told the counterpart to serve notice to the council appearing on the there. So this is okay. Council petition submit, sir. Demand contract to CRP number 1162 of 2023. Deputy Postman along that. Post after 3 weeks. Post this matter along CRP number 1162 of 2023.
Item number 63. P. Varalakshmi.
Yes, sir.
Lord Supreme, please to post it after 2 weeks. We'll file our judgments and we'll finish our arguments.
Last second, I heard matter. Which one?
grounds which they have raised in final action is not there. Second is litigation, third is.
Okay, last occasion. Let advocate argue the matter. Lakshmi.
Yes, my lord. 2 weeks, my lord, due to inconvenience of the.
Other person seeks time. Post after 3 weeks.
Actually.
Item number 60 for Rajesh Kumar.
I think they are taking time because of this.
Yeah, he'll stay in this matter. No stay. Yes, sir.
Yeah. What should no students say that the report that TRP is pending with 2 weeks, you know.
For 2 weeks.
Item number 60 for Rajesh Kumar.
With a post for 4 weeks.
Item number 65, B. Ravi.
55 and 66 go together.
Yes, sir.
And not extended in the legal finance to keep corrections with the matter. The state appeared in final past.
For one case, or not for 2 cases?
My name is Victor.
Okay, one case is the name of the.
Okay, sir.
No, his name is.
In the 2 cases, my name is recorded.
Okay, one, okay, name is there, yes, yes.
It is ready, we will argue the immediate.
Extend the model and make the 2 weeks.
Post for petitioner seeks time to. 6 time. Post after 3 weeks. Election till then. Yes, sir. Just too much.
Item number 67, Muhammad Mumtaz Pasha. B. Vivekanand Pasha.
Last time they asked me not to the counter.
Already demand answers in favor.
Yes, yes, but they are not filing any counter, my lord, so matters will be posted for the.
Final hearing after 4 weeks.
Yes.
Item number 68, Harshit Reddy, law firm M. Sujendra and Sujendra.
Yes, but I'm stating for the respondents that are filed the state petition that the ex party order and not coming forward to argue the matter for a judgment they have taken.
Yes, madam. Deepal vacation will come to the Hyderabad from Supreme Court. Uttam Reddy, sir. Huh? When do you want?
The council before the other bench himself considered that he wants the dismiss the CRP, but only wants to extend this order for another 3 months. The other hand is asking for dismissal and the hand extension of the interim. I oppose that.
Advocacy, sir. Advocacy. Yes.
Change order,
No, don't comment other things, sir.
This order not at all connected, only the order has been passed by this.
In the month of June 2023.
Yes. Not to interfere, it's a petition suit, is my suit. I have
Wait for two more weeks, 2 more weeks. Post for petitioner 6 and post for 2 weeks. Coming first time before me. Election till then.
Item number 69, Vivekila.
But I was compared with obedience of the directions of the. For the
What are the notes to respondents, sir? Unappealed.
I sent the personal notice period to the first respondent received it. Lord, I paid 2%. On 18/7 itself, Lord, I paid. TSR number 65200.
Yeah, delivered, that's it. 536 chips.
Next time the information. Partner understanding.
Inspire service notice. The respondent one. Granted their extended orders. Post is kind of file hearing after 6 weeks. Yes, sir. And the orders, sir, extended.
Weekly.
So this become 500.
Yes, sir. What is notice? What happened? Notice is respondent.
Notice sent to the council, my lord, council refused to take.
Whatever. The respondents.
9860 USR number. The printed form, my lord, the application is filed.
No, that same was rejected by the council, sir.
Correct, council.
You are not only sent to the council only,
No,
not to respondent, sir.
To party also I have sent it, my lord.
No, sir.
I have sent it to the party on 20th June 2023.
6th. Only in the post service says only notice as per. Council appeal with
Only, I
respondent.
think I have to file the acknowledgements of the.
Yes, sir. Convert 6 post after 3 weeks.
2 weeks will have to declare the trial is.
3 weeks, sir. You see, 3 weeks.
And the impact of the person, because I don't know whether the applicants have come, you also can again order person notice. I take out.
Okay, council is petition. We have to take out. Personal response per person.
Respondent 2 and 3 only, because we have to.
Yes. Arun died already. Yes.
Haven't died, 4 and 5 not this.
Item number 71.
3 weeks.
E. Venkatamna, M. Mehbooba.
Yes, sir. You are not here morning. When I there for 2 weeks. When did you? They said that you are only on Tuesday. I am available on Tuesday. That's why I posted on Tuesday. 14th, sir. 21st. And then batch matter. No, not here only.
The only sheet that I am seeking is for disposal of the interlocutory.
In their case, batch matter. Morning. Item number 26 to 33. That is anyone. You want time for filing a replies? Yes, sir, not available this today. Telangana High Court. That's why I posted for 22nd.
So I thoroughly but this has been engaged for this.
Yes, sir.
Morning, in fact, I have already argued the case.
Yes, sir.
Not we have the petitioner in the plaintiff. He files a suit for cancellation of an agreement of sale from GPA that is put into the removal property. Not in the suit, we find an IA. 2017, praying for an interim injunction restraining the response to alienating the property. Not in spite of the injunction order that was granted, if the respondent has alienated the injunction order was granted on 23 to 2017. Not subsequent to that, he has executed sale deeds, where also see at page 37. But pendency of the injunction order, the respondent started alienating the property. He filed an application number 142. Under section 39 2A capital for violation of injunction. That application is pending. Meanwhile, we also filed several applications with regard to 340 giving or filing a false certificate before the court, and those applications are directed to be disposed of. Prior to disposal of 216 that remain a may not should see at page 85. The order also is on the court.
I think I heard all the last before vacation. I heard the matter.
Page 85, the operating portion may not should see at page 92. I report the submission made by the parties considering that this degree can dispose of directly before that we can so and so. But what I am submitting is, along with this IS, you know, the disposing of this IS, let that 142, that 29 we have get filed also be disposed of together, and of course, 260 may be taken. This is the only plain change.
Last occasion, I am not convinced by your arguments. I want to detail, I want to hear you detail. Not so simple, sir. I have last occasion.
This software is there a lot with regard to the other applications. This present subject matter with regard to not alienating property and injection was granted. Let me file an application for violation of English property.
ISR 2017 IS.
2017 IS.
17 IS.
This is the 216 is 2000. Ultimately, the subject matter IA would be a consequential IA to the main OA 260 OA.
Yes, sir. IA 216 IS.
That's Indian starter. Temporary Indian starter. Now, once there is whether that injection survives or not, that's the subject matter. But once when injection is temporary injection is enforced, if they have violated the arm, they are liable and so therefore, let for the court decide whether they simultaneously. I am not asking you, so let them simultaneously take up this IA also, along with the other IAs, while disposing of 216. But suppose the court comes to a conclusion that there is no violation, let them check because registered statements are there stating it there. Loss violation of the orders passed by this Congress. Granting it for freedom, granting it privilege. Now, privilege would be passed to them.
This court directed to dispose of the IAs. What happened to 2016 IA?
They are pending.
2016 of 2017.
Not even a single step has been taken forward. The same status of the suit is as it is. They filed a suit for suit originally in the year 2017. They have obtained an interim injunction which was extended, and subsequently there was no extension. And immediately what they have done, pending the injunction, in order to avoid the disposal of the injunction application, they have moved various interlocutory applications, even going to the extent of disputing my admitted signatures, which I have filed, which the respondent himself has filed, admitting that those are his signatures. They have gone to the extent of disputing the respondent number 1 signatures on the counter. It is for the respondent to dispute, but not for the petitioner. When the respondent himself admits that those signatures are him, even then they are disputing the signatures. They are moving one or the other city application only to delay the disposal of the injunction petition and continue to admit. As such, the court did not extend the interim orders. Subsequently, there was an alienation of the property taken place.
That was in your expired. Show me the copy.
I filed those documents. I could not get it. I seek time, some time may be granted. I filed all the documents showing that interim order was extended from so and so time till so and so time. Thereafter, there was no extension. Even that docket order is also, we have got that docket order also. There is no injunction at all. It was extended this some day, a specific day. Thereafter, on that day, there was no extension given by the Honorable Court. And thereafter, it was adjourned due to the non-availability of the officers. And subsequently, when the court below has taken up certain applications and reserved the matter, they have moved. Twice they have moved the transfer applications, seeking for the transfer of the suit case, alleging various allegations against the officer, presiding officer. Now, even the second transfer OP is still pending, pending this CRP, they moved second transfer application, that is also pending. The whole intention is to avoid the disposal of the suit, and they want to say that the state intention is continuing. But for a moment, the lordship may take for seeking any relief in any suit, a petitioner has to show the primary case in his favor. For a moment, the lordship may take up the contents of the claim. Nothing.
You are asking, sir, you are asking for time.
Yes,
Are you asking for merits? First, you have to time. First, before starting of CR course, you have to mention that I am asking for time.
Anyhow, he is the senior. I don't want to interrupt now. At page 46, for a moment, the lordship may take.
This is very nice submission before we.
No, we are.
Yes. My friend has been submitting that the index chart is not enforced, plus index chart is not enforced. Let the court verify the record. If index chart is one, I would be dismissed simply. Please discuss, my lord, it could not be about separate here.
Asking for condition to dispose same with along with 2017 petition.
Immediately, not thereafter, let the court pass order, verify the record and pass the order.
For the moment, they not, acting. They have filed a suit in the year 2017, my lord, obtained an injunction, and today we are in 2023, my lord. More than 6 years, they kept the injunction application by filing the other various applications pending. And they have obtained a direction from the same Honorable High Court seeking to dispose of this IS in so and so manner. Superseding those others, they want, they have.
They don't file a count service. Office on 6 times. Well, count as post after 3 weeks.
4 weeks, my lord. File counted and also the documents.
4 weeks.
Well, here, my lord, they take it, there they are not pressing for the hearing.
Where is sir? Where is the
My only submission is,
they themselves have five, they have five, my lord.
We'll say, no, don't say all this. Okay.
Item number 72, Muhammad Moin Muhammad Qadir K. Govind.
Yes, sir. Welcome. Conference 6, the respondents, post after 4 weeks. Well, here, sir, I have not seen. Okay, madam. Right, like that. Yes, sir. No, I'm just reading it. Only nothing. Because of the
Item number 73 and 74. Yes, Miller, JV Kalashpari.
Okay. Okay, Vijay Palukar, yes, morning mentioned. First for the response 6 time, post after 4 weeks, independent election, and then. You are plaintiff. Subsequently, with the dengue fever, sir. Mother mentioned that. And that's post of 3 weeks. Okay, post of 3 weeks. Extended.
Item number 75. Yes, Ganesh.
Yes, sir. Yes, sir. Condition interim orders. 7/7/2023. 4 months for okay. Once per the response 6 time, post after 4 weeks, interim election at till then.
Item number 70. Ramchandra Sharma, ME Renu.
May I please respondent 3
Wait,
Yes, sir.
Millard.
is online.
Millard, I am online, Millard.
Yes, sir.
Millard, the limited scope of the CRP is that, Millard, the court below has, Millard, closed the evidence of this petitioner without affording the, Millard, opportunity to, Millard, mark the document. Millard, the brief facts are like this, Millard. The petition before your lordship is, Millard, defendant number 3 in a suit for partition filed by the first respondent herein. Millard, earlier, Millard, while filing the return statement itself, Millard, I have stated in para 14, page number 31, that we have a old document which we are not able to file at the time of filing the return statement, but I reserved our right to file as and when we trace it. Then, Millard, we got that document, then filed that document along with the Millard 3 IAs to reopen, to recall, and to receive the document. Those 3 IAs were dismissed, Millard. We have filed 3 CRPs, Millard, before this honorable court, Millard. Those 3 CRPs were allowed, Millard, while on 30th December of 21. Well, directing the court below, Millard, to receive that document of partition deed. That was the partition, old partition deed of, Millard, 1961 document. That one. That is the crux of the entire dispute. But this court has directed the Millard court below to receive the documents and to recall the witness and to mark the same. Millard, since that document was not sufficiently stamped, that the document was, my lord, supposed to be sent for impounding. My lord, the court below has given the document to the counsel of this petitioner to send it for impounding. But this counsel has sent it to the, my lord, sub-registrar. Sub-registrar has returned that, saying that this is only the registrar who can impound it. My lord, the document has been sent to the registrar. The registrar said, not you, it is the court which has to send.
Yes,
My lord,
court.
yes, only court has sent. The junior counsel, my lord, in the court below has filed an affidavit also requesting the court to send the documents for impounding. Well, without doing that, my lord, the court below has simply closed it, the, my lord, evidence. Lakshmi can see the impugned order at, my lord, page number 7. 7 at bottom. However, the different number 3, different number 3, DW1 not present before the court. This court already allowed the petition to send the document to the registrar to get the impound of the document, and the document is handed over to the party to get the impound. The court till so far document not get impounded by the party. DW1 not present before the court, so and so, so and so. Hence, the evidence is closed. My lord, it should be sent by the court. Defendant number 3 and 4 directed to adduce his evidence called so and so, so and so. So my respectful submission is limited prayer. My lord, let the court, my lord, send the document for impounding, because that is the crux of the matter. And my lord, this honorable court has allowed the, my lord, CRPs, my lord, to direct the court below to receive the documents. Now it is the mistake of the court.
May I please, Your Honor?
Yes, sir.
My lord, the crux of the case is little, I'm not going to the merits of the case. However, my lord, the present IA that is impugned as for them.
Docket, not for IA, docket order.
My lord, there are other things.
Yes, it's a docket order.
So this honorable court, the dates which are very, very important in that case. The suit is of 2014, my lord. If it is seen at page number 11 in my paper that was me. The second paragraph, the earlier CRPs that were allowed. For a moment, if they are seen what the court has observed was, second paragraph, may I read it, my lord?
Page number?
11 as per the paper served on me. That is nothing but the impugned order as per them. It was passed on 28th June 2023.
No, sir.
Well, that is the order that they are. 28th June.
Difference, page number 8, sir. That is 8, page number 8.
Yes, 8.
And number 2. When the mat was posted from different. It's about it. The second page of the impugned order, my lord.
Yes.
Lordships, I got it.
Order of the Honorable High Court and all placed before.
Yes, yes.
That is a registry. The court itself is saying the element, the section did not put the order before the court. That is not the fault of anybody.
No, this is the fault of the counsel as well as the client, my lord. It's not the fault of the court. Court has made it very evident in that. This paragraph and the third paragraph, subsequently, when they are read together, it is very clearly stating that this is no fault of the court. My lord, that if there is an affidavit as per the petitioner counsel has submitted, my learned senior has submitted, even the affidavit that was filed by the counsel of the plaintiff, which is at page number 10, if it is seen, the dates are very important. When this was filed multiple times, they do not present it, neither the client nor the counsel. Now they come up and the counsel files, my lord, affidavit also together. That is the reason. Lordship, permit me, just read it out in coherence, all these 3 paragraphs.
No, sir, who will to send the document impounding a party?
That is obviously, I'm not denying that.
How can they return to the document
They
to
are
the
not
party?
present. This is not, this is not.
Kalara will hit. Yes.
Not the case where the court has to stand on. That is not the point to be adjudicated. The point here to be adjudicated is how many times they have come up before this honorable court and how many times the CRP when allowed also, they were never present in the court. This is only delivery tactic to drag the case. That is suit for parties. We don't know who the
Sir, page number 2 of the order copy. Last para, last para.
That should be read along with that second paragraph.
Allowed to the petition send the document to the register to get impounding the document handed over to the party. That is the issue only here.
That is handed over to the party for the reasons on that day on 28th June 2023. That is not the first time that they are not present. Council was never present. That is the reason for about the earlier CRPs that were allowed also. The last words are very important, subject to the satisfaction of the court. At least
Just continue with the ignition has to come to
But
stop
that
the.
cannot be the ground, man. That cannot be the ground.
Even we are ready to see what is the document, if that document really suffices the crux of the case. That is partition document where they state that they have found some documents near 1963. Actually, in the
Already over, sir. The court already allowed.
that is the reason I'm not on the.
Actual document.
The court allowed, but they file an affidavit which is at page number 11. The date may be seen.
Admittedly,
in the
mistake
last
on, sorry, admitted mistake on the part of the court to.
In such case, to assist the honorable court in the fairest manner, let this be allowed, but let the lordship may fix some time on it. So
Very well. Definite.
let me time fix now. So that immediately they shall pay, and we'll also see what is the.
3 months to dispose of.
Very well, my lord.
Because this is not the first time that they have filed a CRP on this content.
So only second time.
3 months to dispose of the.
Very well, my lord. I am obliged.
Evidence of the.
Very well.
First, court has to send the document to the. This.
Let it be observed. Let it be. This is the court which has to set. Yes, my lord.
It will be fixed in certain time board, man. That's only
3 months.
Very well. Very well. I'm deeply obliged.
So within 3 months to dispose of the. Not dispose of, including the evidence of the defendant evidence.
Very well, my lord. That is, sir. Perfect. My lord. It's perfect.
Let the fairest manner, so that the suit also shall be.
CRPs. Hold on. Directly. The setting aside the tune as possible. Also dated. So dates 2023. Would be related to send the document for importing. Receiving the importing the document. It depends on that. Conclude the difference evidence within 3 months from the date. That's the document. Post of not post. I can't distinguish this program. Yes, sir.
Date of this document or from the date
I'm
of-
obliged, my lord.
Date of this.
From the date of this.
No.
Oh.
Think of this order. You don't know. Take some time, sir. Number of cases are disposing. Take.
Obliged, my lord.
Yes, sir.
Item number 77, D. Madhavrao, yes. Nagesh Reddy.
The IA is also dismissed in March. Prior to.
Yes, sir.
I filed an application, Government of the Commissioner to related local inspection, conduct survey with regard to the suit schedule property. Interim application for injunction filed by them was dismissed. This fact. As a matter of fact, we dispute with regard to the extent of land that is involved in the property.
Sir, you have filed IA in IA.
Yes, sir. And
Sir, IA in IA, not by the separate suit separately.
IA 237 and 238 have been dismissed recently, Your Lordship, and we have preferred a CME against that order. So the present.
You filed a C.
Yeah. So that order has not become final.
No, sir, you have filed IA 5 parties. 5 in 2023 in IA number 237. Now 237 is no more. All dismissed. Not pending before the.
Now that it is pending in CME. Right? Ultimately, what I need to settle before the lordship is.
Yes, sir.
Property is being disputed, localization, demarcation is what is in dispute. And ultimately, your lordship will look at the matter has to be resolved in one or the other way. Now, we are claiming land in the same survey number.
Sir, page number 19, paragraph 15 of the impugn orders. Appointment of Legal Commission is not at all required in IA number 237. Specifically asking for IA number 237 only. The prayer is. That is the page number 19, paragraph 15 impugn orders.
That the other past with the Senate judgment. And my application, the lordship says that my application. Page 47. Page 47 is my prayer.
Page number 43 of petition. IA in 545 of 2023. But strongly page number 41. You typed as IA in so and so in so and so. That is the problem. IA in IA, not for IA. Petition is IA in IA. Affidavit is IA in OS. Now IA is closed. Yes, sir.
That can't be very technical. My subject.
They are ready to argue the matter, sir. Hospital respondent 6 times, post after 3 weeks.
My only contention is that when an IA and an IA is dismissed and
No,
appeal has been preferred, Your Lordship, against the IA.
but he is filed for the not an IIA. In suit, he is filed for commission of
Yes, Your Lordship, that is dismissed, Your Lordship. Even the
No.
IA is
Specifically mention page number include orders. Page number. Para number, sorry. Para 15 of the include orders. Page number 19. Mention that they filed a government of the commission are paid in IA number so and so. But they filed unwritten name suit, but only mentioned as petition as IA and IA.
57 with regards to injunction, seeking injunction with regards to alienating the property, Your Lordship. And IA 545 is with regards to.
Well, here we both of you. Yes, sir. Just 2 days was change that only. When the construction is not that's why. That was 6 times, post after 3 weeks.
Item number 78.
You saw another council, sir, appellate council.
This is a admission petition, Your Lordship.
Someone, insurance company, who is for?
No, APS artist.
Then, it is the name of so and so.
Yesterday was very much present, but when.
Father is not, no, they were not fit to call this, that's the problem, sir. Item 78, no one name applied. Tum Srinivasa, Kadam Srinivasa.
Tum Srinivasa.
Item right, it's matter.
He is there.
Yes.
Taking the permission only for the claimant number only, Your Lordship. My claim was 50 lakhs, Your Lordship. The airport has awarded 40 lakhs 50,000. And the petition number 1 to 3 are entitled to an estate of 3 lakhs each. And 2 and 3 are the minors, Your Lordship. And 4 and 5 are the parents, Your Lordship. I have filed the application only for the claimant number 1.
Application but mention
Yes, sir.
all the other parties, the also. Yes, sir. Head counsel for the petition respondent. IA number 10223. Respondent. Petition number 1 is permitted to the was by the respondent of appellants in as of this court dated 18th January 2021 in MACMA number as per our say. Unfortunately, it should actually also in the account of MA here or the account of MBOP number, you will have to go $50 on the final. More actions claims will come special sessions trials, trial of cases on STs and STCPO bracket act, and then comes one additional distinction session judge. Three lines translated for the court. This is related to the remark. Tum Srinivasa. Yes. Srinivasa was for the appellant. Post this matter for finally after 4 weeks. Yes.
Item number 79, Ramkrishna Reddy, yes, Surendra Reddy.
Yes, sir. Already we permitted to withdraw the amount, sir. In on 6/2022. Yes, sir. Already permission is there. Request vacate petition. Huh? No, sir, my order is there. There shall be interim stay of subject to condition depositing of 50% of the compensation amount awarded by tribunal with interest and cost within a period of 8 years from today. As such a deposit, the respondents are permitted to withdraw their proportionate share as per the terms of the award passed by the tribunal. The order of Justice P.S. Smith, Sisuda Madam. This is yes, R6/2022. And dismiss the IAS vacant petition, sir. Without what is show me, read IA number 4, then where the other copy. Counted with the already. Read page number 8 last, page number 7 last 2 lines and page number 8. Then filing vacant petition without withdrawing amounts. Okay. Here comes the petition as current. IA 1 IA 2 IA 2 3 IA no delays already. I think already condoned, sir. 612 not note down all these things, sir. Forces IA 4 along IA 1 along with the main case. Post matter file hearing after admit post file hearing after 6 weeks. Winter issue comes the current court below. Yes. Post matter along with MICMA number 331 of
Item number 83.
Yes, Srinivas. What about notice servants or not other side? Not served for return, sir. I think. Record personal notice there. First for the applicant. Already I have related to your last occasion on 8/9, but you are not sent notice to the spot. Committed to take out personal is 1, post on 4 weeks.
Item number 18, 134.
Which sir, madam? The plans post after 4 weeks.
Item number 82. Please Srinivas.
Yes, sir.
In the ready.
R3 for the one, I think, number the climates. Names. The climate is R1. Muhammad Ashir. Record person respond and 1, sir. Most of the covered take out. Person respond number 1, control post after 4 weeks.
Item number 83, Ramakrishna Reddy.
Yes, sir. About response that your last occasion also same. First time, sir. 28/6, I granted interim orders. Yes. On 23/8, I'm not load, I think. Yes, not load. And 20th/9 also. Okay. First, for the promoted take out, performance control service post after 4 weeks. I think all other matters are same, similar thing. Full up to 85. Same matter. Item 83, 85, 83, 84, 85, same. 86, not by Wakala. Sir, not only by Wakala. Wakala to not by the vacant petition.
Permission petition.
Yes, yes. Cause per 8, 8, cause per file number 1256 and post after 2 weeks.
2 weeks.
2 weeks.
Plus.
Of December, sir. Normal. I posted on 2 weeks means 24th, 24th, sir. One admittance post of file is, sir. Again, you have filed a ticket petition. Permission also. Yes, sir. You take up both my IS only.
Item number 87, please bring the same Vijay Reddy.
Yes, sir.
Only claimant we have filed HIGHCOURT.
Yes, sir. How many days delay, sir? Get cost for this correspondence. Delay of also days condoned. Therefore, get cost for petition thus far, right? Petition permitted to the most possibility. As per the art of this code dated 36/2023 in IA number 3/2023 in MSCMA number 2023 in VOP number 1412/2018 on the file of what actions claims tribunal Court of TSHC Court Hyderabad for furnishing any surety. Main case admit post of finding after 8 weeks in time which comes the court below. Yes, sir. Permitted.
Item number 88, please bring us Mohammed Ismail.
Yes, sir. Command July, sir. IA2. Take off the present respondent. Delay of source of this control. IA4. Take off the present respondent. Petitions are permitted to withdraw the amounts as part of this code dated defined by the appellant. The person of applicant complaints as part of this code dated 28/2023. IA number 3/2023 and MSCMA number 700/2023. The account of MEOP number 190/2019 on the file of what actions claims to not come. The court of TSHC Court Hyderabad. As per the share appropriately without furnishing any surety. Main case admit post of finding after 8 weeks. International Department Court below.
Item number 89, G. Srinivas.
Final respondent, sir. Take out person notice, sir. Post take out post after 4 weeks.
Item number 90, E. Balakrishna, A. Ramakrishna Reddy.
How many days delay, sir, this matter? Local respondent filed local condition. 577 days, sir. Okay, one of the applies post after 4 weeks.
Item number 91, G. Srinivas, A. Pavan Kumar.
Yes, sir. What are you to how many days delay, sir? Yes, sir. Are you to here control petition respondent? Ask him, sir. I also this delay control. I have to take up the petition respondent. Petition number 145. Submitted. The most possibility. Respondent appellants as part of this code dated 26/2023 IA number 3/2023. MSC number 8/2023. The account of MEOP number 409/2020 on the file of what actions stems to welcome positional decisions among hypothetically approximately for any surety. Let's go for the number 1, 4, and 5. Not 12. Every post of finding after 8 weeks. Instead of recount the current court bill. Yes, sir.
Item number 92. J.S. Lakshmi.
So both sides for 4 weeks.
Item number 93. Pillar and
Don't go offense post after 4 weeks.
item number 94. K. Ajay Kumar. Yes, Divakar Reddy.
Yes, sir.
And for the respondents members, I have filed IA3 members. Request a petition.
Yes, sir. What is IA? What moment is this? IA1, IA2? No delay. Okay.
They were granted with this. Wherein my lords, I am only seeking permission to withdraw the deposited amendment.
Yes, sir. Take cost for IA number. We have 2023. Respondent. Petition number 1, 4, and 5 is permitted to withdraw the evaluation. Respondent have applied as per the order of this code dated 9/2023 in IA number 2 of 2023 in MACMA number 9 of 2023 in the account of MUOP number 109 of 2018 on the file of more actions claims to come. Useful decisions. Jaginchar. As per the share approximately without furnishing any surety. Yes, sir. Main case. Already, madam, sir.
Already, my lord, there is a connected MCMA, my lord, wherein my lord's appearance. Let's hear in file.
Post that of file hearing along with MACMA number
832 of 2023.
832 of 2023 after 8 weeks. Meter is comes the current court below.
May I take copy?
Not today, sir. Will come. What the agency?
Nothing, my lord.
Will come, sir. Within 1 week, it definitely will come.
Bless my lord.
item number 93. Krishna Rao.
No, but petition has post after 4 weeks. Apply the last 4 weeks. You are here. How can you say, sir? Calling, okay. Please R1, what sir? R3 served. R1. R1 is contesting respondent. One of the vehicle and climate, driver are necessary. I think. Ask one. IA number. Service notice. No respondents. Take cost for the petition for the request. How many days delay, sir? Delay of delay so unload. Admit. Postal file hearing. After 8 weeks. Meet up with the current court below. Sir, don't see the boards are have to hear the court officer. Huh?
Item number 96. G. Rajkumar.
Yes, sir.
The insurance of each lot.
Notice of pardon for the served. Return the served, sir.
By USR number 107.
Yes, sir. Yes. Haven't been there. IA2. Results notice. Another respondents. Help of a petition. They left 80.
8 days.
Only 8 days. 87 days, sir, not 8 days, sir. Sir, first you have to see your bundle, not online. 87 days. Huh? No, that depend on the online. Yes, this is control. Post of finding after 8 weeks. We can discuss the control.
Item number 90, G screen was.
Item 97, 98, request hospital after 6 check, post after 4 weeks.
Item number 19, MP Ramakrishna Reddy.
Okay, post it. Post after 4 weeks.
Item number 100, C Kuchiri.
Sorry. Post after 4 weeks.
Item 101, item number 102, M Satish Reddy.
Yes, sir.
It's just not so long.
First notice, sir, but better to take first notice correspondence. Diamonds.
Connected matter is 472811.
By the way, you are on the other side.
1027. 1047.
Not take a first notice. That is
And the council. So written answer.
okay, labor. Then the house number is there, sir.
But it was written, it was a first agreement.
Okay, coastal, upper committed. HIGHCOURT. First notice. The response has coastal period for the response in court below. Appeared in court below. Post after 4 weeks.
You made up 2811.
Right, sir.
Connected matter is posted on the same.
Okay, post on 28. Level 2023. Along with MSCM number 1047/2023. Yes, sir. Meantime, you have to solve the.
I'll search the council.
Item number 103, yes, we make it from 30.
Your correspondent means RP means insurance company. Insurance company. You have objection. Federal delay. Electric. We have 24 days, sir. Not more than below 1 year, sir. Nothing will happen, sir. Take consultation respondent. We have also this control. In case admit, also find the ring after 8 weeks. International the first court below.
Item number 104, M Thousand.
Yes, Ashok.
The respondent number 1, today only we have 5 of that. Request 2 weeks.
It comes first. Okay, third party. You are no insurance. One of the yes, sir.
Respondent number 3 is the driver.
Yes,
Respondent number 1 is the
climate. Yes. You want time, sir? Yes. Cost number. I think the respondent number 1, 6, 10.
Subject to my lord's the connected matter filed by us.
First you file vacate. Permit will withdraw the amount, sir. Then that is better. Post after 2 weeks.
Item 105, Another comma.
Sorry, no, sir, madam. Okay. Process finance post after 4 weeks.
Item number 105, B. Krishna Rao.
Sir, actually, unpaid on 8th of 2023. Okay. Every day. Yes, sir. I have an order. I have to save 50% along with the 36 weeks normal number. 8 weeks. Process finance post after 8 weeks.
Item number 107, Ajay Seven Kumar.
The second time, right? Their list means 811. Okay. This must also be the matter. It will appear. Okay. I have an order. I know finance. Post of 8 weeks. Post for the upgrade. I want to take out for service.
Item number 108, yes, Surendra Reddy, sir, yes, Alexander.
You are the petitioner. You are question that I told you last time. What, Mr. Yes. Of course, they don't know. Only the number of the respondent. Now he is died. How can I contact anyone? First for respondent. And post after for orders. Post for submits them. The level shows them. The respondent expired. Listen, the last of this last April 692 file memo to that effect. Post for orders after 1 week. Yes.
Item number 109, yes, Avani Reddy, B. Vimal.
On both sides. Post after 4 weeks.
MRT.
Progress has opened the 4 weeks.
Item number 111, Durga Prasad.
Yes, madam. Post for 6 petition for social service of the respondents. Post after 3 weeks. Election till then.
Item number 112, Syed Yaqub.
No business. Post after 4 weeks.
Item number 113, K. Malaya.
Yes, sir. Sir, what about notice of respondents?
My lord, the respondent is not received minor 3 times and respondent council is received on 2 occasions. 10, 8 and 8, 10, second time received.
Okay. What is last CMP? Right file the last CMP.
No, sir.
FCOP filed by the respondent.
No, FCO is filed by me.
P6 of law filed by the Vikhya Supriya.
Yes.
You filed in Warangal. What is the reason?
Last evening edition.
Because the file here also is the president of the Hyderabad.
Yes.
Okay. It was also noticed another respondents. Here cost for petitioner, post for orders after 2 weeks. Yes.
Item number 1 for TSHC.
Petitioner. Post after 2 weeks for dismissal.
Item number 115 N. Vijayendra. Yes, Vijay Krishna.
Post for petitioner. Matter like to come back. Post after 3 weeks.
Item number 116 Mirza Shawat Nawaz Beg. Magatlal Madani.
Yes, sir.
Very beautiful analysis in the last 3-4 days, 3-4 years. Pointed out that both the suits are different. Properties shared and run in.
So the last citation, 39, request of the respondent. The filing counters, 27-9, another both sides, 11-10, and request of the respondents. Seeking times are every time. Not respondents will take seeking time. You are the respondents, not a petitioner. First time is not here. First one, number for the petitioner. Post after 4 weeks. Wrongly, Carbon. And the docket times.
At no point of time, once that, the last may remember that very first time in an argued matter, I pointed out that both properties are different. One is in Nagari court, another is in court.
No, sir. No. First time I will file counters in this matter.
Yes, no.
Okay, see, sir, after 4 weeks.
20th July, that I went home.
So we'll see, sir, after 4 weeks.
Item number 117 J. Govardhan Reddy.
Okay, post after 4 weeks.
Item number 118 P. W. Lakshmi Shankar.
Has been filed.
Who comes the petitioner? The respondent, sir.
The petitioner.
Petitioner?
Yes.
Who is the respondents? You are representing Pabbara, right?
Yes, I'm representing Papa.
Lakshmi Shankar Raya Reddy.
He's appearing for me as a student.
Well, counters also.
Yes, ma'am.
No counters, sir. Yes, government wrong condition. Yes, sir. What is this case? Use mic, sir. The voice is low up today. What is the reason? Huh?
This is the application filed by the wife seeking the transfer of the OP. Petition is not residing and is not working. Also, the petitioner is studying in the school.
Okay. Care cause for petitioner, another respondent. Post orders after 2 weeks.
Item number 119. They are but
So, the correction notice is sent to the council as well as the party. Both are served and then no on 7th and 2023 not yours. The wife seeking transfer to the husband.
Yes. Care cause for petitioner. Professors, other respondent. Post orders after 2 weeks.
item 128, item number 121. P.N. Murthy.
Yes, sir.
May I please, my lord? I am for the petitioner. Wife is the petitioner. She is seeking transfer of HMOP 83 of 2023 on the file of Senior Civil Judge Medpalli to Armor District.
Please serve to not, sir.
Notice served, sir. Notice is served on the respondent as well as counsel on record in the trial court. Acknowledgements I have filed.
23.
My lords may kindly see
Sir, come off returns are not served to respondent.
page number 3 of the memo.
Sir, 1 minute. Return. Not served
No,
to
no,
respondent.
personally the returns are personally it is served.
Personally, how can
That's
you
what
serve?
I'm saying. Page number 3 of proof of service memo.
How can he receive personally?
Personally has received.
How can we know signature of the respondent, sir? How can we identify signature of the respondent?
And counsel he has endorsed his stamp also.
Counsel received, I accept it. Not
No, no,
stamp.
counsel.
So who is P. Sudarshan? Stamp is there. Signed by you.
Not
Yours.
Sai Reddy. K. Sai Reddy.
I already signed signature only.
Mahesh is his counsel. Mahesh is his counsel. He has endorsed his
No,
stamp
sir.
also.
Suresh is the counsel, but there is no stamp, sir. Involved. Received notice. Already signature. We don't know.
Yes. Sai Reddy is signature.
Sir, who identified signature of the Sai Reddy, sir?
He received it, nobody identified.
Yes, that's the problem, sir. We don't know.
Shall I take out fresh notice, sir?
Sir, counsel, we have to take out. Proposal is post after 4 weeks.
Obliged.
Item number 122. Subramanian.
Yes, sir.
May I please, your lordships? In this matter, my lord, the notices were altered and were sent to R1 and R2. The same were returned as unclaimed.
Yes,
And
sir.
this was sued for partition in respect of the same property between the brothers and sisters. I filed in respect of the same property before the.
What's the cost of paying for respondent, sir?
Pardon, sir?
Cost of paying for the court below. Respondents. Because person respondent appearing. Cost of petition for take court. Person response appearing as a cost appearing for respondent in court below. Proposal is post after 4 weeks. Yes, sir.
Take out personal notice here to the respondent advocate, sir.
Yes, sir.
Obliged.
Item number 123. G. Sanjeev. Vijay Kumar.
Yes, sir. Happened. Not in the court.
Notice serve kaapata order illirukku. Notice serve. Andina.
First respondent seeks time to file counters post after 3 weeks. Change in your favor. Yes.
Item number 124, Mandata City. A Pradeep Reddy. Submission said the wife is currently residing in Hyderabad. She is working here in a private company. She has only business even by seeing the way of distance also. Hyderabad is around 250 kilometers from Hyderabad and 190 kilometers from Hyderabad. So it's convenient for the parties to participate.
Where is the counter, madam? Counter copy is not with us.
Number 2.
Not put up by the risk. IA number 2 is there, but not. IA number 2 is there. Roll call for petitioner. Madam, what's the petition? Yesterday, it may not be put up by the risk. Roll call for respondents. Post after 3 weeks. 3 weeks. Post after 3 weeks. Link and Vishal to put up the IA 2023. Yes, sir. Nothing happened, madam.
Item number 125, Rajesh Nair, Nageswara Pujari.
May I please, my lord? I am appearing for the petitioner, my lords.
Yes, sir.
Notice is out, my lords. Even respondent filed wakalat. This is wife seeking transfer to from Mettipalli to Secunderabad, my lord. HMOP 154.
Yes. Someone appeal.
There's appearance, my lords. Nageswara Pujari filed wakalat.
My lords, we need time to file our counter, my lords. 2 weeks time, my lords.
The counsel for the respondent seeks time to file counters. Post after 3 weeks.
Oblige, my lords.
Item number 126, D. Venkateswara, K. Satyanarayana.
So the 1 month. First time they have filed wakalat. Wait for correspondence. Post after 4 weeks. Yes, they are already there. I've seen.
Item number 127, yes, Sriman Prasad.
For the respondent.
I'll ask them now. How can they know? You filed wakalat.
Recently we have filed wakalat.
Then you have to ask them to file give copies. Okay. Petitioner. Correspondence seeks time.
From Major to Elminar, even this distance of 50.
Why are you asking the band? You have no band. For the petitioner. Correspondence seeks time. Post after 3 weeks.
Item number 128, G. Rajesh Murthy.
My lord, I am appealing for the respondent. Papers are not served on me in spite of direction by this court. I have not received any papers.
Okay. So they want to.
After hearing this honorable court directed the petitioner counsel to serve me papers.
Yes, sir. Today is not appeared, sir. No other petitioners. Post after 4 weeks.
Oblige.
Item number 129, G. Annapurna Reddy. B.
Yes, madam.
Associate is fine. We have solved the papers also. We are.
Someone filed wakalat also, madam. Yes. Another cause of respondents. Post after 4 weeks.
Item number 9, we have to.
Okay, post out of 4 weeks.
Item number 10, K. Chandramohan Reddy.
Yes, sir.
For the estimate degree class in the case number 2 of 2022. File upon the principal secretary that I take it. Collect before your last page, number 2 in the suit. As part number 1 hearing file the suit invoice number 95 2016 for partition. The said suit is dismissed by the trial court. But was dismissed at 11/11/2021. May kindly see the findings of the trial court at page 38.
Yes, sir.
There are 10 users. To support the question of the plaintiff delayed on exhibit A1 to F1. Exhibit A1 is the Bahani for the year 97-98. Bahani. Year 97-98, the property survey number 109 to an extent class. Standing in the name of Sorokandi as a Pateda. Exhibit A2 is the Bahani for the year 98. This Bahani 2000, number 2000. Standing on the name of the Sorokandi as Pateda. Exhibit A3 is the computerized copy of Bahani obtained from Niseva for the year 15. As per this Bahani, survey number 109 and extent of 40 kilometers standing on the name of A3 is having another Bahani for the year 2015. Regard to the survey number 501 by 1 to an extent of 6 seconds. And also is survey number 15. The extent of Haneka stands on the name of Prakati Rajireddy. Therefore, the Rajireddy is the appellant before your lordship. Therefore, the exhibit A3 having 3 Pahanis, those were stands on the name of Prakati Rajireddy, who is the son of Sorokandi Narayana. But the plaintiff did not explain with regard to entering the name of the Sorokandi Rajireddy. That is the defendant number 2 in exhibit A3 Pahanis. Why? Because plaintiff submitted to the social properties in joint portion in the enjoyment of the plaintiff and defendants. The exhibit A3 Pahanis goes to show that property was located on the name of defendant number 2 and mentioned in column number 14-15. In exhibit A3 is the Pattal and the Rajireddy. That is the defendant number 2. Exhibit A4 is also 2 Niseva Pahanis. And pursuit of these Pahanis, survey number 2054 to an extent of 39 root stands on the name of defendant number 2. For the another Pahani marker and the is for survey number 2060 to an extent of 11 root standing on the name of Sorokandi Gangara. So who is the Sorokandi Gangara? In what way is consent to the suit? Why the plaintiff filed this Pahani dated 7/10/2016? The name of Sorokandi Gangara is also not explained. This court and the plaintiff failed to file the other revenue records to show that the father of the plaintiff was named Sorokandi Narayana as a purchased property or had acquired the property and except the exhibit A1 and A2 Pahanis, there are no documents filed in the plaintiff to support the claim government. Why? Because plaintiff submitted the property claimed by her belonging to Sorokandi Narayana, who is her father, but whether her father acquired the same from his father or ancestors is also not clear, and on what basis plaintiff mentioned the boundaries. If the land was surveyed, whether the boundaries are mentioned using a physical question is also not clear, and no independent witness is examining to support the plaintiff versus and more well. As on the date of filing of the suit, property not stands as the name of Sorokandi Narayana, and the plaintiff also not taken any steps for the rectification of revenue entries. Therefore, on considering the aforesaid facts and circumstances as per the discussion, plaintiff failed to prove her case, so she is not entitled to partition. He has not at all adduced any evidence except examining herself as PW1, except marking as exhibit C1 to
No, sir, all expert, all set ex parte.
all was set,
Including
myself. Yes, that's the supplement before your lordships also. But the luck of this, how little balance suit is dismissed. Not satisfying the same, she preferred again first appeal. First appellate court, without considering the findings of the trial court, by giving upon its own, at the page 26, your last page, can see page 33.
Page 26.
26 para 33 minutes. Further, all the defendants were remained ex parte. This suit was read before the trial court. Even after service of summons, none of the defendants, including the defendant number 2, contested the matter. And as such, the contention of the plaintiff remained unchallenged. In support of her contention, the plaintiff has filed Pawani's expedient to court so as to show that the suited properties are the answer. Because they were set ex parte, therefore the contention of the plaintiff strengthens that basing on these findings, that the decrease the suit. Like the opinion sitting aside that I could judgment. Questions of
The questions of question you have not filed any statement in the court below. Filed a special petition before the court below. And then
because the suit itself was dismissed. Therefore, ballot to the lockup. If it is a ballot, the ex parte degree, your lordship sir. It itself is dismissed.
Dismissed. Okay.
Yes.
No, first ex parte, then only they suit dismissed. First
ex parte.
Ex parte, subsequently they.
The suit itself was dismissed. Yes.
Penalty. Then I will hear both of you after 2 weeks. Meantime, the question will nothing will happen, sir. Only partition decree.
Degree.
Yes.
In the guise of this.
Immediately they will not file any petition to apart of the commissioner.
They give such undertaking, but they will file tomorrow itself. File a degree petition.
Yes, sir. It will take time, sir. Now we are contesting now.
The moment they file it, will be the any time it can be filed. Only prayer is to suspend this appellate court.
First, admission only, then only the orders, sir.
Yes, your lordship can see my substantial questions of light based annual. Question itself, my lord. The findings of the first appellate court are contrast to that of the trial court. It itself is a substantial.
Sir, I have contested in the appeal.
I contest. Yes. After receiving this summons, we have first appeal, they contested, they made the council.
Okay, all the spots are contested.
This appellate only.
Separate only? No.
Main this appellate is the.
Yes, sir. Actually, trial court given a specific finding.
Yes, in that findings, the appellate court will actually that findings section. Page number 25 section. Page number 25 paragraph 13. Paragraph 29 section. Page number 24. According to the plaintiff pressure after death of the Narayana, the second person being the male member managing the suitable property with the consent of the plaintiff and the other co-sharer, review the citation report the suit for the factor of the case are not simple because the name of the second defendant when placed in the revenue record XPA2, it can be taken for the granted that he is the absolute owner of the suit property. As per the family decree, one of the the lower court, the trial court finding that the plaintiff failed to who is this Sunkara Gangama to
Sorry, Gangara.
I tried to filigree the plaintiff specifically mentioned that the original owner the ancestor the Gangara, Sunkara Gangara. Sunkara Gangara was the common ancestor, and there is a clear reading that the property or the ancestor property, which means Surkanti Narayana inherited the property from his father, Surkanti Gangara. The trial court wrongly observed that the plaintiff did not explain that whether the father Surkanti Narayana either purchased the property or in the acquired property. And also in finding that the page number 32.
page number 26, para 32. The document filed in the plaintiff clearly reflect that the name of the Surakandi Narayana in respect of the property in survey number 109, the property covered by survey number 501 stand in the name of the second defendant, where item number 3 of the suit property stand in the name of the Surakandi Gangaram, who is none other than the common ancestor of the plaintiff. Even the entries in the Bahani taken into consideration of the suit property are the stand in the name of the Surakandi Narayana, the second defendant, and Surakandi Gangaram. 34 in the same parameter, page number 24. It is well settled that the one co-owner is the actual position of the joint property, and other co-owner of the either options are not in the actual position. It later will settle the contract to.
So you not filed a plain copy.
They not filed.
What protection the property? What less protection the property? What is the?
Item 1 is 4 acre 11 gutas in survey number 109. Item 2 is 6 acres 19 gutas in survey number 501. And 1 acre 4 gutas, 9 gutas and 11 gutas in survey number 2054, 2055, 2060.
When waste. Plain copy is not here.
It's not.
No, actually, what is the pleadings in the plain that are?
Pleadings are that the property is owned by a father.
Any quantified by you in the appeal?
Appeal only contest.
Without a statement, without counter. Where, how can you take into account, sir? What is your stand in the appellate court?
It is first way kindly consider. Good below has not at all, first appellate court not at all considered anything, will you last way kindly see?
Sir, where is it? No. Pleadings on behalf of you. By morally saying something. How can you take into account by the appellate court?
The last way kindly consider the plaintiff who approached the court who had not succeeded in the trial.
Then you have to.
They have to establish.
Then you have to contest that. The appeal as your expert in.
Yes.
Story.
Even in
I'll
expert.
for 2 weeks, sir. See up. First, I can see some for 2 weeks. No, meanwhile, sir, nothing happened.
Other notice, I'm only seeking.
Not your file counters in the appeal.
Other notices to the other respondent.
Okay. Then I'll post it. 227. Post after 4 weeks. Post for upload. How to take out? Notice to the respond number 227.
227. 2 already, no more.
Okay. 327.
List contribution item number 131 BJP Karakapari.
Possible 6 times post after 4 weeks.
Item number 132 G Ravichandra Shekhar Srinivas for.
Yes, sir.
Lord, in this matter, we are appearing for the respondent. We are filed by counter ballot yesterday.
Item 132 Porava Srinivas.
Yes, but I am appearing for the respondent, brother.
Okay.
I filed by counter also.
Narayana's phone, your okay. First respondent 6 times post after 3 weeks. Yes, sir. There is no stay, sir. Already I have seen last occasion. I think same. This filing number of cases in different courts.
No, actually, petition was withdrawn.
Yes, sir.
But at least small.
Second case, already they filed counters. Already filed counters.
Yes, my lord, counter is filed.
Yes, sir. Already filed counters.
Yes, but I filed counter in this matter yesterday.
Yesterday, already the record. Further response 6 and post after 2 weeks.
137.
And counsel for respondent, right? Respondent 9, my lordship. We filing Okala. Request for time for counter and hearing.
Office of Bears was actually case was PR Machwara, madam. Come on, reference. Look at the petition. After part 6 time. Post after 4 weeks.
Item number 134, G. Sundaresh.
All the petitioners. Post after 4 weeks.
Item number 135, Om Prakashna and Bhavishra Pujari.
Yes, sir.
Number petitioner. Respondent received notice. Aneshwara.
Yes, what is the stage of
Wakalat filed
what is the stage of the case, sir? Topi?
to be trial.
2018 matter.
Trial. Posted for 14.
Evidence of petitioner respondent.
Petitioner.
Respondent is completed.
Completed. Petitioner is completed. Respond. It is coming for respondent evidence.
Response means petition hearing, sir.
Hearing.
Petition hearing.
Yes. Posted for 14.
Appealing for last since 5 years.
The interest.
No stay, sir.
Respondent received.
No respondents post after.
Already received.
I am saying that no because for respondents, sir. Reference is there. Nageshwara Pujari filed Wakalat. It is not appeared today. Regarding the same and urgent matters, sir. No for respondents. Post after. No, sir. 5 years over. Post after 3 weeks.
You are a practicing doctor at Paramdar.
Sir, appearing for last since 5 years. One more adjournment.
Respondent threatening.
Item number 136, G. Srivas.
Next, vice transfer CMP to transfer this thing.
11.
That was half time.
Okay, 8 level. Okay, okay.
That we have 5% transfer CMP to transfer HTMP over 6 to 2023. And what to be carried back in that. There are just issue has performed with the respondent.
You have not filed any 498A?
No.
Road division. Post of right weeks. Post of the petition. Order to take out from the service. I1. This will solve the FCOP number. Section 2023 on the file of Judge. Family court, civil court. By mentioning family judge, civil court. It was.
CMO stated in
Family mentioned that. You have to mention correct number. Already number, case of number, some particular case.
Case number, page number 8. Family, yes, family judge, civil court. Therefore, we are saying it is the same way.
Family court. Which family court? Civil court. Bracket integrated. Karpataru. Yes, sir. Matter stay, sir.
Stay.
Stay granted, sir.
Okay.
Post of 8 weeks. 8 weeks. You got personal discount.
Item number 137, Mohammed Sidam Basha.
COP 137 of 2021 family court at Varangal. Transfer the same to the family judge among the six members. The COP is filed by respondent for 1 year. And retired employee can.
Okay, well, wife, not wife, The respondent. Huh? Yes, you are. He's claiming as a right. Yes. Yes, sir. Confirmation, post of date, please. Also, petition committed to court. Offer purpose service. However, there will stay of cause proceedings in FCOP number 1,2021 on the file of family court, family court. Family, what is this? This family court at Warangal.
Item number 138.
Is that taking the grounds of deadline of the 488 pending and DBC going to be filed in that?
Going to be filed, also filed, sir. As per your corporate, also filed. Also filing, DBC.
But not numbers. Taken wrong address as a residence, but actually came from USA and married and stayed 3 months in Nizamabad town and went to USA. Not the time that he resided.
Okay. Permission, post out trade, please. Post petition. Order take out for service. I have a service FCOP number 969 on the file of Principal District Session Judge from Family Court, District at Malkazgiri. Yes, sir. Understand.
Item number 139 in 40. Krishna Mathuram, D.S. Soumyaji, Ajay Kulkarni.
Both sets. Over 4 weeks.
Item number 141. P. Krishna P. Rohit.
Yes, sir. Open the breaks. Over 6 times. Post after 4 weeks.
Item number 142. Nanda Adam.
But on behalf of petitioner, advocate, press notice.
After the plan, submitted record. Post after 6 weeks.
Item number 143. Krishna Mohan.
After the 6 times, post after 4 weeks.
Item number 144. Rajkumar.
You are for? Also for 6 and for 2 weeks.
Item number 143 and 144. P. Venkateshwara. And Babu Permanent.
In the field, Millard, I am for the 419 of 22, I am for the appellate.
Yes, sir.
There are two council notes included by the respondent dependent. Both are set to examination for the lectures. For one promissory note, they said if you be callous that of the dependent, and second they said they cannot give any opinion on that. Based on that, the original defense of the dependency that they never signed anything. They are only, these are all the fabricated documents. They have not signed anything. There is no necessity to take any loan from the plaintiff. So when once we sign the number, it is that for one, it is Signing and everything, so that the trial court is not taken into consideration, that the entire defects, that the fabricated and all those things is not correct, declared in our favor. The second appeal, when the second appeal comes.
First appeal, sir. Second appeal is here.
First appeal comes, then my respondent has filed the first appeal. I was the respondent in this first appeal.
Yes.
The appellate court disallowed the promissory note of 1 lakh rupees, and because it has not been completely approved by the policy department, that is our signature. They said they cannot give any opinion on the signature. Only first appellate in appellate court. And that is the disallowed. Also, the appellate court granted leave for the promissory note allowed from the date of filing. So I agree with that because that is 31 says refiling contractual interest also has to be paid.
Yeah, partly allowed.
See, allowed partly allowed even in the partly allowed amount also. Section 34 will have been for your lordship. The principal sum has to be attended. Take into consideration the refiling interest from the date of execution of the promissory note. That has not been taken into consideration. The second point I was bringing to your kind notice is the appellate court also has all the powers of it and the trial court. He could have got the documents and verified for itself whether the signature tallies or not. It is the Supreme Court also said when the expert opinion is given, it is not compulsory on trial himself. The judge has to satisfy himself. And whether the signature tallies or not, and then only has to deliver the case. This Justice Ramana said very well, Chief Justice. So I bring to your notice, they themselves at the Supreme Court verified the signature themselves, and then gave finding. When such is the position of the law, the appellate court, without asking for any records or verifying them, in satisfying itself that it is not so as far as it is reserved, that's it. Promissory note may not. That's why I before your lordship.
Yes, sir.
For its second appeal, this for second appeal. This my contention is the appellate court has not followed the 34 of CBC in allowing the refiling interest. Second, the court ought to have verified itself, getting the records to satisfy the court itself that whether signatures are tallying or not. Third point is the order says there is a collateral evidence for the 1 lakh taken by the respondent by way of figure, then there back record. Then this court in its order state there may be so many other reasons for which they take money, and there cannot be evidence for this concept. Then the very defense itself says there is no need for them to take money from the plaintiff, and the entire case is fabricated.
This will not actually.
Cannot agree with it. You cannot find any evidence or anything. You go to
Notes already filed wakalat. He filed wakalat. Okay, I will.
No, but anyhow, your opinion now at this stage,
Yes, sir.
Now I have received the copies, Lord. From my yesterday, I saw the copies in my appeal. In this, Lord, actually, the suit is filed by the.
Actually, there is no notice ordered by this court. This matter, no orders, sir. Orders. Only
Personal notice, sir. 490, it is 490.
403 issue notice to the respondent, that is.
Yes. Even 419 also, when admission came, it was added notice.
Then,
File of 419, I have filed credit bill at first, lordship may have to EMI, if you are kind, the lordship will treat us, and then pass an order on 490.
No, 490, your name was not printed, the file is only.
14th November, I filed the credit, there is the record of the.
So next case,
Today I served the copies. Today I received the copies in his office.
Then I'll post from the other day, sir. Issue notice response only this man. The KVT was not put up by the registry, sir.
It was the prime minister or something, after they were not put up.
No, not put up, your name was not printed. In 2000, that was listed on 13/12/2022. Again on 18/4/2023. Your name was not printed in the call list, I think.
They are not printed, but the credit of the application filed by me on 14th November, it's in the record of the file bill.
4th 2022.
14th November 22.
The appeal, second appeal filed on 16th November.
I am talking about 419 bill.
Yes, 490, I have seen 490 also. 490 also. Second appeal filed on
22nd November.
whether KVT is a number or not, we don't know, sir. Okay.
This will have actually the suit filed collusively by the husband and the person against wife. And there was a dispute between the wife and husband, and they have created the promissory note, and the pleadings which they have depending on the transaction is purely on the bank transactions.
So your wife means your appellant is now wife.
In the 490.
490, appellant means wife.
Yes, this is the Ravindra Desai is the husband of the appellant. He is set ex parte. He set ex parte in the suit. He did not contest it.
Wife and husband is colluded. Husband and
other party colluded. Filed the suit against wife because
they are not living together.
Yeah, they are not living together. They have the disputes. She is the second wife for him, and they are.
Okay, I will hear you after 2 weeks, sir. Both of it. This was post after 2 weeks.
Eight million.
24/11.
Item number 147, M. Narasimha Reddy, Ashok Reddy Company.
After 27th,
Okay, post for 3 weeks, right? Post for 3 weeks, sir. 112, sir. 1st December. 112. Yes, remember? Yes. Okay, post for a friend. After the 6th time, post after 4 weeks. For this, there is no stairs.
Item number 148. M. Krishna D. Padmavati.
Yes, sir.
Citation not a note, but already observation citation. Second and 3 weeks time not
Post for the 6th time, post after 3 weeks.
Item number 149, Vedal Chitralekha, Chairman name.
In this matter, we have to state nothing further on this matter. The matter has been carried on SSB, but no orders in that state.
Okay, he wants exposure by the external file against Indian orders. No orders.
In that SCP matters and no orders is there. Nothing.
Yes. of the respondents. Post this matter. Finally, after 8 weeks, this is the right to call the court below.
Item 149, 159. Item number 151 adjourned. Item number 152 Ramchandra Venkati, K. Ajay Kumar.
Yes, sir. Our demands valid. So, not for the vacant post per 6 times, post after 4 weeks.
Item number 153 is followed. Please agree.
One day holiday report, sir. Friends, 6 times, post after 2 weeks.
Item number 154, J. Srinath Reddy, B. Srikanth Reddy.
Yes. The yesterday mentioned this matter.
Yes. But there has to be concurrent finding.
Okay. Post after 6 times, post after 3 weeks. Individual arrangement till then. Yes. All right, excellent. Done it, sir. No. Okay. Huh? I have granted. On 22/8, sir. Before filing a work, yes. Emergency respondent, individuals candidate. One person individuals. And before me. 17/4.
Okay.
Status quo granted by 17/4.
Last technically, lawyers have expressed that it is not admitted. Okay.
Item number 155, N. Krishna, Kim Prabhakar.
Both sides quoted 4 weeks.
Item number 156, MS Rajat Bharadwaj, appearing behalf of the petitioner, my lord, if lodged is dead, but to issue personal notice in the
Ma'am.
Okay.
May I please your lordships? My lords, I'm appearing for the respondents, my lords. I'm filing my wakalat today. Kindly grant some time, my lords.
First respondent 6 times, post after 3 weeks.
Publish minutes.
Individual election till then. Yes. Yes, madam, what is the mention? This matters you have mentioned? Okay.
Yes. Political.
Yes.
District irritated.
Convert. Consul both sides post after 3 weeks.
Item number 159, K. Muralidhar Reddy, B. Mahendra Reddy.
On both sides, for 4 weeks.
Item number 160, M. Damodar Reddy, J. Rajeshwara.
Yes, sir. Okay. For not really, post for the after 6 weeks time from the respondents. Post after 3 weeks.
Item number 161, K. Anup.
Post after 4 weeks.
Item number 162, M. S. Chandresh, K. Venkatamraya.
Yes, sir. For 6 times. Point number 6 weeks time. Post after 4 weeks.
Item number 163, Sujit Jaiswal, S.R. Deshmukh.
May it please, my lords, appearing for appellant, my lords. My lords, in the stay was granted subject to filing of 50% of decretal amount, my lords. The same has been filed, my lords. Memo is also filed to that effect.
Decided, madam.
My lords,
Right order, okay.
stays there, my lords. We have deposited the amount, 50% of decretal amount.
Because respondents.
My lords, S.R. Deshmukh, sir.
For respondents. Post after 4 weeks.
Oblige, my lords.
Item 164, item number 165, Gopal Pushkala, G.L. Narasimha.
Because on that day,
2 weeks was 24th, sir. For 6 times. For respondents. Post after 2 weeks.
Item 163, G. Mansur Reddy.
Post after 4 weeks.
Item number 167, K. Sanjeev Kumar. Please, Ravan Kumar.
Council for appeal. Last time said we read out the judgment in the said well after this is the trial court and appellate court at Stilla. Now for challenge that I mean second appeal in order. Thing is whether Milord is said basically it's ancestral property Milord. Out of the court to judgment is one of the plaintiff.
Sir, who is for respondents? Someone filed Wakalat, Ravan Kumar.
I filed the personal notices to all the defendants prior, but I know so nobody has come down up with the court.
No. Filed Wakalat, sir. Ravan Kumar.
Not for I am for a appellate.
Yes, sir. I am asking who is for respondents. Who is for the respondents? Post after 3 weeks. Next time, see, sir.
Give me a chance to because last time
Next time,
I read out the judgment is said.
Next time, sir. Next time I need you. Yes, sir.
It's into section 9, but she does.
Sir, no, for respondent here, sir. I will hear next time. Or next case.
68, K. Lakshmi Manohar, D.
Yes, sir. Milord,
One call, sir.
168, I responded to the file. We filed already counter membership. We are ready.
Yes. What comes happens? Post after 4 weeks.
Item number 169, arrangement committee, Sanjay Reddy.
On both sides. Post after 4 weeks.
Item number 170, which was J. Venkateshwar Reddy.
On both sides. Post after 4 weeks.
Item number 171, D. Sudarshan.
Post after 4 weeks. Make it right.
Item number 172, Mangalam K. Sanjay.
On both sides. Post after 4 weeks.
My lords, I am for the respondent number 1 in this matter, my lords. In item number 172.
170?
2.
Representing whom, sir?
Respondent number 1, my lords.
Present for your council. What is the name of the council?
Council Sanjay, my lords. Sanjay K.
Post after 2. Last one. 4 weeks. First class letter. On both sides. Yes, sir. All next please.
Item number 163, Kalyanagashwar MS San.
Yes, sir. The respondent.
My lord, I am for the respondent. My lord, I am representing Mr. Anwar Siddiqui. My lord.
Ready?
My lord, in this case, we are filing additional documents. My lord, council and record is out of station. My lord. Kindly, next date may be given. My lord, we will file additional document in this case. My lord.
Go ahead. 4 weeks.
Item number 174, K. Shravan Kumar.
Post after 6 time. No the respondents. Post after 4 weeks.
Item number 173, Sheila Ashok Reddy.
Post after 4 weeks.
Item number 176, Muhammad Alan Muhammad Ilyas.
Because for apply post after 4 weeks. 4 weeks, sir. No demand in this matter. No order, sir. No order, sir. Right? Yes.
Item number 177, P. Krishna Reddy, A. Prabhakara.
On both sides. Post after 4 weeks. No question problem.
Item number 178, M. Narasimha Reddy, B. Raghavan.
On both sides. Post after 5 weeks.
Item number 173, VJD Paratkar, Yelwani.
Post for the respond seat. The first applied 6 time. Post after 3 weeks.
Item number 180, Ravinder Reddy.
Yes, sir.
Vice number 9 of 12. Seeking partition issue to be property loaded.
With the respondents.
Classification they took time and also served the paper on 16/10/2023. Served the paper at the reversing judgment school by the claim appellant agreed by the lower court. Was reversed by the appellate court.
Only hearing after 2 weeks. After 2 weeks only hearings. Respondents for 2 weeks.
Concurrent findings with respect to the boundary.
Please, madam, please. Sir, all of you, mute your cameras. Another case reaching you. Unmute your camera. Yes, sir.
The substantial question of one that the suicide from boundaries.
How many days delay, sir?
That is delay of representation, 1390. 1000.
First take notice respondent, sir.
No, delay in representation.
1390 days, sir. Carbon wonder.
Delay in representation, largely may put to some cost and it can be taken. Only delay in
After
voice
notice respondents, I will definitely I will. Another.
No, one sufficient. I'm not speaking anything. One sufficient. Delay, there is a delay. Then you largely will give 1 day also notice as to discover. This is delay in representation, largely to put a cost on the petitioner. Who will pay the.
Normally, advocates.
Largely kind of question. Here the problem is.
They are not pursue the advocate. That's the problem.
One sufficient. One more sufficient.
Their parents also 100 days, 200 days. And part of the advocate in the office for 39 days.
I'm ready to pay these things because unknown the corona and other aspects have been taking place. So, and we have found.
Excluding corona only, they think this will calculate the delay.
That is total. They have calculated.
How can they?
Yes, 2019. They have calculated only with respect.
There is calculation.
And meanwhile, the respondent for selling the property as if they are more, because even though the issue was taken.
Take a notice, the better to take notice, sir.
Cost maybe.
Not cost, sir. Notice only.
I'm ready to pay with that.
After notice only, sir.
Only one request I made with that.
Yes, sir.
So for the property.
They are perfectly great. You have to.
I do understand. Yes, sir. No, what happens? She sells the property. There is no address for a person is 2 days after. Root myself that I'm the owner.
Yes, sir.
Only because of the boundaries. It's a difference.
I will let it know.
That's only the otherwise I could not. All this.
Melons, I beg to appear for the respondents in this matter, Melons. Melons, I request 2 weeks time to file a counter and conduct the matter.
On 6 time, for 4 weeks.
Obligement.
My lords, I am V. Nageswaram, my lords, appearing for second respondent. Your lordship may kindly grant time for filing counter in IA, my lords.
Okay. No comes to apply. Also on 6 time, post after 4 weeks.
Much obliged, my lord.
Yes.
Item number 184, Syed Yasir Mahmood Muhammad.
On both sides, 4 to 5 weeks.
Manjari Islam.
I beg to represent for the respondent in the matter, my lord.
Yes,
I am audible, my lord.
Yes, yes.
I am for respondent. I am offering wakalat in this matter, my lord. Lashma, can you take this matter of after 2 weeks, my lord? Meanwhile, I'll bring the entire file, my lord.
First, 6 time, post after 3 weeks. Hospital remark, further see her now, post for the respondent. Yes.
Much obliged.
Item number 186, P. Vishwanath Reddy.
Look of the parents post after 4 weeks.
Item number 186, yes, Rahul Reddy, Sudha.
Yes, Rahul.
Rahul Reddy, my lord. I'm sorry, my lord. I'm on
Not
online. My lord, this is a second appeal, my lord. There is a condone delay in representation of 124 days. My lord, there are two senior citizens, if your lordship should recollect, with respect to, my lord, juror relationship of son and father, but not tenant.
Same building.
My lord, I'm sorry, my lord.
Same building, son and father, father parents.
Yes, my lord. Yes, my lord. Yes. Your lordships may kindly be, my lord, the Honorable Supreme Court. My lord, I filed the Supreme Court judgment along with the suit itself, my lord, along with the file before your lordships.
For respondents.
My lord, already your lordships got their name printed on last occasion, my lord. They filed KVI, but they have not appeared.
Last second, their name was not printed in the call list.
Yes, my lord. Your lordships directed their name to be printed last time. Their name is printed, but they have not come.
The 187, they're not expected to reach the matter. That's why
I totally understand. I'll leave it to your lordship's discretion.
Post after 1 week.
Very well, my lord. I am deeply obliged.
Okay, cavitas, post after 1 week. Next week I will release it.
I am grateful, my lord. I am obliged.
Yes, sir. Morning mention for Saturday, Tuesday. What urgency? Yes, sir. They best. Cavitas last occasion, last time.
Small countenance matter with immediate subjective loss.
Then where after taking time here, they find that is their previous last. Yesterday also they mentioned, I think. The mention is
on Monday, Tuesday. Can we get instructions on that?
No, sir. Across the bar, mentioning morning and yesterday morning, today morning also mentioning. Urgency.
On Tuesday.
Already given time 211, sir. 2nd November, you have taken time. Yes, sir.
At that time, they have not failed the case. They are not failing it. But subsequently, they fail institution.
What is your case, sir?
This is the second note which is filed against the judgment and decree passed in the ASM 392 of the Constitution. The suit was filed for eviction after causing a notice in the section 106 of TPS. But the crux of the matter is not in the specific case of the appellate before your lordship. The tenancies, there are 3 different tenancies. Technically, the lease was granted on 3 different days. In 2001, a portion is property was let out to the appellant. In 2003, a subject property was let out to the appellant. In lordship, this loan for money was let out on a different day. But the contention of the appellant is there are 3 different tenancies. If you take the 3 different tenancies, but the rent payable in respect of these 3 tenancies is less than 3,500. So that falls within the jurisdiction of the rent control. They have initiated the proceedings in 106 of TPA. Their case is not that all these 3 tenancies were merged. Subsequently, they were merged. And it became a single tenancy. Therefore, the proceedings under 106 can be initiated. That appears to be their contention. That such a contention is accepted or not, but you not should make any of the movement the appellate court judgment. 292, page 24. There are 24 national. There are 24. On the perusal of the case, page 22. Page 20. Yes, there are 22. From the perusal of the case of the plaintiff and the testimony of Peter Levan, the initial budget therefore is on the patient to demonstrate that the lease for the 3 portions which were admittedly obtained and different dates to the defendant not merged into a single. Admittedly obtained as 3 different dates, that the defendant not merged into a single. But this is what is observed with the appellate court in 24th list. Lordship can see the entire judgment, the subsequent paragraph. Unfortunately, the lower appellate court did not address this point at all.
Sir, senior counsel, please, the meeting, what is going on?
Lordship is the appellate court has clearly observed to demonstrate lease for the 3 portions which were admittedly obtained at 3 different dates. Admittedly obtained at 3 different, in the case of positive, both the parties.
But the judgment got merged into single. For the respondent plaintiff to establish these three leases which were initially granted separately, they were subsequently merged. That was observation made with the appellate court. But if the entire judgment will not, this unfortunately the lower court has not addressed this issue at all.
So, sir, what the issues covered by the court below?
Court, points for consideration. But there at
As first point, first issue is there, whether the court is having jurisdiction.
Tenancy is composite and single and dispersed in three different portions. Both by cogent and acceptable. Now the crux of issue.
Page number.
Page number 16. Points for consideration. Page 16.
Trial court. Trial court
finding.
Page number 39. Issue 1.
Yes. That this court is having jurisdiction to maintain this. Unless the plaintiff is able to establish that these three tenancies which were independently granted initially, they were merged together subsequently, and the court will not have jurisdiction. Yes. Because it has to go before the rent control. When they are independent tenancies.
Yes, below 12 times. Yes, sir.
So therefore, not the burden heavily rests upon the plaintiff respondent to establish that the three independent tenancies not merged into a single tenancy. My submission not, the trial court will not without lordship again appreciate the burden will be upon the plaintiff. Unfortunately, the trial court also failed to observe that the plaintiff was not able to discharge such a burden.
What is the other is OS, sir? OS number 513/2007.
Lordship again is the appellate before your lordship. There is an agreement of sale between the parties. And I filed a suit for principal party. That was dismissed. I filed an appeal against that in CCC. But TCC is concerned, arguments were heard and it's reserved for judgment. Principal party. It is reserved for judgment by this court. Therefore, not the judgment is yet to come in principal party suit, like appellate suit. And apart from that, goes to the very root and jurisdiction of the trial court. If the plaintiff respondent is not able to establish that the three independent tenancies were subsequently merged and it became a single tenancy. That's what the appellate court also observed in judgment. The burden rests upon that. Unfortunately, the burden was not discharged. And in this issue, the para 24, the court itself formulated the legal position. But para 24 of the appellate court judgment, the court itself formulated the legal position saying that the burden rests upon the respondent plaintiff. Unfortunately, in the subsequent paragraph, nowhere it is mentioned that the plaintiff respondent was able to discharge that burden. Para 24 lordship tells at page 22. Page 22, para 24. For the conclusion of the case of the plaintiff, the testimony of given the
Yes, I have seen.
Yes. Subsequent paragraph, nowhere it is mentioned that the respondent plaintiff was able to discharge that burden. Once the court formulated the legal position, it failed to address that part. The fifth case to be admitted.
The pleading page number 41 and page number 13. And could others also same pleading page number 41 para 13. Page 41 para 13. One page.
Defendant also corruption that as defendant claim to promotion differently. Court is not maintainable for all three principles. Provisions that he has no application to these. The question is found good as no judicial evidence.
What is the answer? What is the answer given by the
issue number 1 and 2? They were addressed at page 43. But the answer is not at page 20. Para 20, page 40. As again, this oral document refers to the plaintiff. The defendant himself referred to the witness box and he detailed his defense in his chief examination. The cross examination is stated that he is doing crime business. This is the suit premises under the name and style of Mukesh Flyway. The fact business has been running there for the last 3 or 4 years. Here he used to do electronic business in the shop. He used to maintain the ledger for his business. And he has taken the plain schedule premises on him. With the ground floor, he has taken one multi and the entire first floor was taken for residential purpose. And he further admits that he took the portions in the first floor. One portion made into a month and first floor was taken March 2003. There are no conditions except rent, retailing, and the plaintiff. AWR further admits that ground floor money is a smaller one. There are steps to first floor inside one. Scheduled portion is situated in partly commercial, partially residential. He between him and the plaintiff is equal. And he did ask the receipt for rent paid by him. to state that there are no enhancement of rent since from the inception of the lease. This is all just to statement, but my submission is not. But the immediate fact is, the lease was granted in different years in respect of different portions. So they are admittedly different leases. But the specific plea that was taken by the plaintiff respondent is not that these three leases are not much. Therefore, the burden squarely lies upon the respondent plaintiff to establish that these three independent leases are not much. But either the trial court or the first appellate court have addressed that issue. They addressed the issue that the plaintiff respondent was able to discharge that burden. Either the trial court or the first appellate. Having held that the burden lies upon the plaintiff. The appellate court has clearly held the burden lies upon the plaintiff, but neither the trial court nor the first appellate court were able to say that the merger of the leases is established. But for that, the reliance is placed upon only that part of the cross-examination of the legal one.
Okay, once for the respondent 6, once for the respondent applicant 6 times, post after 4 weeks, you learn both for determination, satisfy the share included. When I ask for sir, auto pass the yes.
Item number 189, click already considered.
Post applied 4 out of 4 weeks.
Item number 190, click again, see Ramesh Babu.
Appellant cannot be applied the conditions in the deposit 10 lakh rupees. It arises out of the dismissal of the test side application. Justification, the junior colleague of the other side has that should take instead. They are pressing for the ruling of the
From 30 lakhs, you have divided 10 lakhs.
Yes.
You will see after 3 weeks, you post the respondents, post out of 3 weeks.
Item number 1920, Ananthan Sena, click again.
Justification also is for appellant request for added after 2 weeks. Justification also I start for time of the parties. Separately.
I will inform.
Okay. Post for the appellant 6 time, post after 3 weeks. Print time. Offer better to serve copies other side. Form 6. Yes.
Item number 192, please
May it please, my lord. May it please, your lordship, appearing on behalf of respondents, my lord. Yes, my lord, counter has been said. I'm ready to argue the matter. The point for consideration before my lord is, my lord, if the petitioner permits, my lord, only one submission, my lord, his grievances, my lord, the lower court has already heard the matter, but has not passed any orders. This honorable court may direct the lower court to pass an order within a period of 4 weeks or 6 weeks, madam.
Yes,
sir. His grievances ex parte order has been passed, and though the vacate is filed and it is heard, the orders are not passed. The court may direct the court of first instance to pass order within a period of 6 weeks.
Yes, Sharath.
My lord,
And my lord, one point I wish to make. My lord, this order came to be passed on 17/4/23. The learned judge, my only case was very simple. On a memo being filed, every date of hearing, the learned judge could not have passed an order. Therefore, automatically the order becomes a nullity. The extension itself becomes a nullity in view of 2016 2LT 557. There cannot be such an order of the learned trial court extending the order on a memo.
It could not have been. So automatically, whenever my friend has the very first memo that has been filed, the order becomes a nullity. It could not have been extended. That's the short point.
Well, if my learned counsel is
yes, dispose of the CRP, the direction to dispose of the IA. That is only submission by the respondent.
No. Now that there is an order itself, a nullity extension, as of today, there cannot be an order as of today. We cannot say that the order is subsisting. That is my contention.
No. That time to dispose of IA, sir. Third time. You don't want extending the orders till the disposal of the IA. That is
Your Lordship may say so. Let it be kept in panel, let it be decided on merits. So till then it will be kept under abeyance. Interim injunction will be kept in abeyance.
Well, no. My lord, my submission, my lord, if he's arguing on merits, my lord, may be posted on the anytime next week.
Yes.
That is better, sir.
I have no problem with the Honorable Court directing the
No, there's a technical question, legal point here. That's the reason.
Both of you physical, that is better, sir.
Yes, my lord. Order expires today, my lord. Interim order expires.
Yes, your lordship. Yes, your lordship.
After the response seats and post after 2 weeks, even an election till then. Yes, sir.
Interim order is extended till then, my lord?
Yes, sir.
I'm grateful. I'm grateful.
Item number 193, Vivek Jain,
Yes, sir.
Petition in this matter. Last petition we were directed to take out notice in laws of council. We have filed in urgent hearing this matter because the trial is beginning in the lower court. The immediate petition was dismissed, against which we have referred the CRP. The CRP petitioner is a agreement holder, registered AGPA holder. In a similar IA, which matter went up to the Honorable Supreme Court, the co-agreement holder was also impleaded. We stand on the same footing over here. Our implead was dismissed by the Honorable Trial Court, requesting urgent hearing. Senior Counsel Rajesh Kipati Rao is appearing in this matter.
1 minute, sir. You shall notice to the counsel appearing for respondents. There is permission to notice respondents. There is no direction from this court to notice the counsel appearing for the respondents in the court below. On 20th 2023, Justice Shamkoshi, and for petitioner submitted the notice and issued the respondent stands served. And for petitioner further submitted the respondent fact stating a state. Order to take court notice on the respondent and time of service. No, sir, that is not a proof of service. We filed a notice to the M. Durga Prasad, Shamsundar Reddy, these must certificate. How can you? What is the date, sir?
Dated 5/10/2023.
Subsequently, this court directed 20th/10/2023. You have filed no proof of service 7/11. How can you serve notice to the respondents, sir, without serving notice to respondents?
Yes, sir, my lord.
Sir, again I am repeating, on 20th/10/2023, this court directed to serve notice again, for respondents only. No service, the same?
So the unserved.
Yes, sir, unserved respondents. Serve notice, counsel appearing on the response, some names, we don't know. How can we serve, sir, without permission of the court? Moreover, normally the counsels are not informed with the parties. Party has to approach the counsels. First, then you are serve notice as per the orders of this court, sir. 20th. Counsel upon petitioner seeks time to comply with this court on 20th/2023 for serving notice respondents post after 4 weeks.
Item number 194, submission of case title.
For respondents. Specific direction is there, sir. Now the objections raised by the land cost for the petitioner, the respondent claimants are not permitted to withdraw the deposit amount. I will hear it both sides, they are not here. Don't come for appellant. Post after 2 weeks.
Item number 185. Item number 185, Ajay Karan Kumar.
Most of the friends post after 4 weeks.
Item number 196, Ajay Kumar Nageshwara Kalpakala.
Yes, sir. Yes, sir. I1, I3. Yes, sir. Accommodate, huh? Take cost by petition respondent. It has provided to the amounts deposited by the respondent of appliance. Account is dated 28/7/2023 in IA number 2 of 2023 in CMA number 8/2023 in the account of MVOP number 418 on the side of water access claims to come to the CH at Badale Kottagudam without furnishing any surety. Main case post for finding after 8 weeks decided come the current court below.
Item number 197, Pradap Narayan Sanghi K. Ajay Kumar G. Ravichandran.
Council offense post is matter for pioneering after 4 weeks.
Item number 199, Yes, Ravitej C. Venkataman. 98.
198 now. Ravitej both sides. Post after 4 weeks. And before 4:30, we were matter reached. Huh?
Item number 199, Sharad Sanghi.
Post for the applicant seeks time. Post after 3 weeks. Huh? Post after 4 weeks. Fill them. Yes, madam. Virtual mode. Action is demand after 4 weeks.
May be granted, your lordship.
Huh?
2 weeks, your lordship.
You are not
As per
ready.
my vacate
Also-
petition, your lordship.
But you have a negotiable action.
It may be taken up next week also, your
4 weeks. 4 weeks. Sir. Don't take chance.
obliged.
Yes, sir. Ajay Prasad Center, David Seekers.
Yes, you are saying blame on the council, last occasion. Huh? How can you know, sir, you are practicing advocate at High Court. How can you know the changes of the jurisdiction of the courts? Blaming on the council, appearing in the council. You are also practicing advocate here only. Huh?
Before reaching,
As well, you have to mention also the wrong, sir, in affidavit on council. Okay, council knows. Place of the jurisdiction of the courts. Party has informed the council, the High Court.
Blaming of 5 million. Blame is not in the knowledge of me and my counsel.
Across the bar, last case, whatever said, in the council may done a mistake, not inform the court, that is your submission, last occasion. Huh? Seeking prayer, sir. Asking seeking prayer or order, sir. Already matter disposed of.
Not disposable.
And you have filed convention.
We mentioned if suppose any technical defect,
But you are asking for.
we amend the prayer.
The only main case. How can it be? Once the case is disposed of. Again, ask.
Names and court names of.
Ready to file confirmation, not amendment of petition. Not mistake in your part, sir. Not mistake on the petitioner respondent. Only you have to reasons the bug. Same one, this was changed. File a petition. We'll correct it the same one for passing orders. That is better. Post per. They can petition that post after 1 week. Well, better.
Item number 2.1 this reverse Kevin Madhu. Be Mayuredi.
Of the appliance post after 4 weeks.
Item number 2.3 yes, Chandrasekhar.
Yes, Mangala. Yes, everybody.
After the record with that.
Already called for the record, sir. Admit, then also applicant is permitted to take out personal respondents. Okay. Go to post applicants, post for 6 weeks. Meet is the record the course below. Yes, sir.
Item number 2.4 Lakshmi Narasimha, M. Rajkumar.
Go to both sides. Yes, sir. Okay. Who's for respondents? M. Rajkumar. Say in your favor. Was stayed. No comment respondents. Post after 3 weeks. You already. Your fellow expired, sir. What happened? It expired in the month of July. 18/7/2022. I said that. Already extended for orders, sir. 22/8. Under for orders. Then only posted for hearing.
Item number 2.5 the Venkateswari.
Madam, honor you mentioned. On 6 and I have extended in the matters, madam. The matters madam action and the for orders on 6/9. Huh? Post for the respondent 6/10. Sorry, post for the it has 6/10. Post after 4 weeks.
Item number 2.6 SG Nadim Muhammad Abdul Rashid.
Both sides, post after 6 weeks.
Item number 2.7 ADK Espressa.
Post for 8 weeks.
Item number 2.8 Srinivas Madiraj.
Post for 8 weeks.
Item number 2.9 KSM Murthy GL Narasimha.
Post for 8 weeks.
Item number 2.10 K. Srinivas Rao Karnataki Soma.
Post for 8 weeks.
Item number 2.11 K. Vijay Nominated D. Venkat
Both sides for 8 weeks. Then here. Yes, both of you. Yes. Ready? Standing for the insurance company. Madam. Item 211. because of both sides, post after 4 weeks. Thus, MA final hearing matters. Already argue the matter. Insurance company, ready? Ready? I will hear you and pass orders. After 4 weeks, yes.
Item number 212.
Yes, in time, you are in time.
Rohit.
Yes. Yes, sir, you are in time. No customer appliance post after 2 weeks or 4 weeks.
Item number 218. TV Kalyan Singh Ramchandra.
So for respondent, respondents here. Appliance are not. After no customer appliance post after 4 weeks item. Button food, yes. What is dash?
Item number 218. Krishna Reddy came information.
152. 226. Yes, what is matter? Okay, already vacant patient granted all the matters.
Before that, already amount with the wrap.
Okay. Employees can compensation. What's the plan? Post after. When the matter already records. Post after 8 weeks. Meantime, this card records in court below. Yes.
Item 225 added. Item number 226. Madhavi Srimantana. G. Masudan Reddy.
From both sides, post of 8 weeks. The final hearing, post of final hearing. Discuss the records in court below.
Item number 227. P. Srijan Kumar Reddy.
R1. Okay, post after 4 weeks. The offense.
Item number 228. Yes, Surendra Reddy.
Post after 4 weeks.
Item 229. Yes, Surendra Reddy.
Okay, post after 4 weeks.
Item number 230. Ajay Shravan Kumar.
Okay, what is the post after 4 weeks?
Item 231. Ajay Shravan Kumar T. Mahinder.
No, both says post for final hearing after 8 weeks.
Item number 232. Palis Srihanna.
That's enough. We are done.
Your claimants appeal, Milad.
What are notice to respond? You are not
filed order, Milad. Acknowledgement card not received, Milad. Notice sent, but acknowledgement not received, Milad.
Process parents post after 4 weeks.
अच्छा,
Yes. मतलब पार्लियामेंट कुछ नहीं डिप्टी पार्लियामेंट कुछ पार्लियामेंट सुने ना डॉक्यूमेंट
Your Honor, appearing for the petitioners. Your Honor, we are led by senior counsel. We request it's posted next week.
मैडम बात डॉक्यूमेंट पार्लियामेंट कुछ नहीं मैडम competition 6 time local customer respondents post after 4 weeks
Your Honor, we request next week or 2 weeks time, Your Honor.
related to delete the caption from part heard. Yes.
Much obliged, Your Honor.
Waiting the first submission matter. Yes, sir.
It's Tuesday, madam. Either man. Yes, submission.
Yes.
I apologize.
Post for the upload 6 time. Post after 1 week. 1 week means on Friday. Monday weekend. Today then.
Number 235, MA Bali, VLNG के मूर्ति.
This is for default.
Item number 236, Samir Kumar Reddy, Arvind Kumar.
This is for default.
Item number 237, M. Siddharth Rao, TV Acharya.
May I please, Your Honor?
Yes, sir.
I beg to appear virtually, my lords. My lords, I'm appearing for the appellant. I'm the judgment debtor from the City Civil Court appeal, my lord. City Civil Court. My lords, I have filed 6 IAs, my lord. That is LR petition, condone delay petition, set abatement petition. There is no counter has been filed by the respondent. So that is a thing going on, my lord. The matter is getting listed from past 8 months, my lord. I've been appearing every time, my lord. There is none is appearing from respondent, my lord.
The last time 12-10. None of the applies only the matter post for dismissal, sir.
Yes, my lord. My lord, that one time I did not appear, my lord, due to
Capture for dismissal on today.
my lord. Yes,
Huh? Say
my lord.
all these things.
My lord.
Coming actually, the matter was after last 23/1/2004, the matter was listed on 6/2023. Second time 12-10, not for 8 months.
No, my lord. The matter was listing, but did not reach the court. Did not reach the bench, my lord. The matter was yesterday also. Matter was listed, my lord.
Yes, sir. Weekly list every day it will come, sir. Whenever it reaches, you have to ready to argue the matter.
My lord. My lord. 2 weeks may be given, my lord. 2 to 3 weeks, my lord. I'll be.
Monday to Friday list. List Monday to Friday, sir. Old matters, you have to wait. Post for the appearance 6 time. Post after 2 weeks. Please catch from the dismissal. Yes, sir.
My lord, a small submission, my lord. I'm permitted, my lord.
I have critical catch from the dismissal, sir. I will hear after 2 weeks.
My lord, the IAs are pending, my lord, so that caption may be for as an interlocutory application, because without disposing IA, I cannot I be able to present the main case, no, my lord. That's
I rather the IAs. What is IAs? IA 1 of
IA is LR petition, my lord, and condone delay petition.
I have filed total 6 IAs, sir.
Yes,
One
my lord.
is 2019. What is the delay of commentation delay?
Some matter of some 40 days or some, my
You
lord.
have no bundle with you. How can you
My
file
lord.
without bundle? Yes, post after 2 weeks.
Obliged.
Without bundle.
Obliged, my lord.
Item number 238, Indian Narasimha Reddy, M. Harsh.
Done. Okay. This is for default.
Item number 238, A. Ramchandra Reddy, V. Narasimha, M. Dhananjay.
This is for default.
Item number 240, A. V.
I'm for the respondent.
The appellant, sir. This is for default.
Item number 241, yes, ready, case Sai Mohammed Naidu Chirku.
News for default.
Item number 242, Muhammad Ilya.
Yes, both of you ready? Huh? Sir, you are virtual mode. Respondent counsel, you are ready in your office, but counsel appearing in the court physically, he has not bundled. Asking for time. Srinivas, money.
Milord, I am ready. Milord, I am sorry, Milord. I am ready.
You are with in your office, it's library, but he is
Yes.
without bundle, seeking time. Huh?
Milord, I leave it. In fact, Milord, we argued this matter on the earlier occasions, 2-3 occasions. The only point, Milord, that has been
Again, you have
the
to
last occasion. The last occasion it was adjourned, Milord, on hearing both of us, and then a citation was given by the appellant counsel, Milord, my learned friend, Milord, wherein he is relying upon a judgment of Gujarat High Court, Milord, that whether the lamination can be delaminated and the expert's opinion can be forwarded or not.
Lamination was easy. Article is bundle. You want fixed time and post after 1 week.
So blessed. Because it has been argued. My request is, Milord, that it has been argued. We both of us have argued the matter. My friend knows that.
Yes, argued. I'll post after 1 week this matter.
So blessed.
I'll post Friday or Monday, 20th.
Monday, Milord.
Monday, 20th. Post on 20th.
Monday.
Yes, sir.
Monday. So blessed.
After it's post on 20th. No. I don't know. One hour mentioned for the exercise 70 hours. I said, wait for 4:30, you will see. If you not exercise, I will run. Yes.
Item number 243, Kalindranath Reddy.
No, both sides. Post for dismissal after 3 weeks. 2 weeks, 1994 matter. 2 weeks.
Item number 244, B. Rehan with TSHC.
No cause for appellant. Post for 6 time. Post for dismissal after 2 weeks.
Item number 245, Manjari Iskan M. Premaskaram.
Yes, madam, I am waiting for successfully one. Not listed the matter in dismissal. Huh? What is the issue, madam? I want to see one.
Okay, ready the arch.
I'll do one, madam. Please don't happen. Spend a couple of hours. Madam, you are what's requesting 1998 matter. Huh? 26, 21, 9, 17, 10. What is matter actually? You have no idea. Partition. Okay. For the upland 6 and post on 20th. 20th level.
Number 246, B. Venkatapur, yes, please.
On both sides. Post after 2 weeks. After dismissal.
Item number 247, A. Narasimha Reddy, T. Venugopal.
Yes, sir. Ready. Yes, I will hear you. Who is the respondents? E. Madan Mohan, Amradhan, and P. Gopal.
So since there are no interpreters, there must be execution proceedings have been carried out or not carried out, we don't know. If there is anybody for the respondents,
in only in that case, it will be possible to ascertain as to the amount that has been realized, whether it has been paid or not, Your Lordship. Anyways, Your Lordship, I'll brief Your Lordship to the facts of the case and the merits of the matter.
Suit for?
Suit for recovery of money, Your Lordship.
No, sir. Polish 1 minute. Yes, sir. Have you bundled?
Yes, sir.
Suit for?
Recovery of money, Your Lordship.
This is suit for partition. That is the order. OS number 1998.
This OS number 214 of 1990.
CCCA number?
CCC number 158 of 2000.
2003 or 2000?
2000. CCC 158.
One minute. The registry put up the bundle up 2003 CCCA. This is suit for partition. We are ready, but for bundling are not. Moreover, if no intimates in money suit, you have no idea about the EP. Once they are educated EP, okay, they will definitely will contact by the client. If they are not paid an EP, if argue this appeal against you, we don't know. Orders against your client. Again, they have to call the service and they will file the EP. That is the problem for you.
We have tried to contact.
That is better to go in section. That is better.
So as a newcomer, I want to argue.
When with the senior, that is better. If you argue the matter, on minutes I pass on orders against you, against the client, the cause continuation they will file the EP. We don't know whether they file already 23 years over. Why argue the matter when we discuss with the senior? That is better. Yes. Constable appointment 6 times post for 2 weeks. I mean 12 years for filing EP. They don't file by EP, they cannot do anything. Argue the matter pass, I emitted an order and problem for your client.
Not in
Then you simply mention that I will approach the CCCA. No instructions. Yes, that is better.
Item 248 and 248. MBA for MBS Kurushina.
One on both sides. For dismissal after 3 weeks.
Item 250, 250. Random Ramesh and Raman.
On both sides. Post for dismissal after 2 weeks.
Item number 250. MB Durga Prasad Sunil T. Lakshmi Narayana.
Yes, madam. The respondents. No question of rights for dismissal after 3 weeks.
Item number 250 for Manjari Islami and Shobha.
After 6 times. Post after 2 weeks.
Item number 250 players Srinivas Reddy, Karun Kumar.
With your lordship's kind permission, your lordship, I will be the appellant in this matter, your lordship. Or should we kindly take it after 1 week, your lordship?
What is matter, sir?
This matter has come to the branch.
Okay, yes, madam, what is this matter?
Lordship, in this, we are filing a memo, your lordship, where we have addressed letters to the bank, but they have not responded yet. So we are requesting the notice to be sent by the court itself, your lordship. We'll file a memo within a week's time, your lordship.
Sending notice to the respondents, madam. We're not admitting any one party. They have to appeal, otherwise they dismiss the case. Appeal.
We have sent a letter to the bank, your lordship, but we have not received any response from it.
I will record a statement and close the case, madam. Non-possible appeal. 2002 appeal.
grant a week's time, I'll file the memo, your lordship, or at least 2 days time to file a memo.
Madam, matter coming from 2/8/2023, 24/2023, 19/9/2023, and
May I have it on
2023. Last 4 times. This is 5th time reaching matter. Last 4 again, same representation.
final time for last time on Tuesday, your lordship, I'll file the memo.
On 24/8, no, both sides. On 19/9, Nalco supplied seeks further time to get instruction from the client. On 18/10, Nalco for the applicant seeks time for getting instruction. Again, today same thing. After
Lordship,
4
I have it on Tuesday, your lordship. I'll file the memo until then.
after the applicant submits that.
To my instructions.
Yes, sir.
It is a matter pertaining to the surpassing related, this was there. And there was a settlement within the bank. And the bank has not received the material papers of the particular case. Due to migration, it appears that the concerned bank is not having the material papers. Settlement is arrived at earlier.
Already settlement arrived. Unnecessary pending the case.
Necessarily it is kept in the
Counsel for the applicant submits that. They have no instruction from the applicant, and the counsel appearing for the respondent submits that. On instruction submits that. The matter is already settled by the parties. Long back, no same, no cause or no service this matter. Regarding submissions made by the first both sides, the matter is closed as infructuous. Yes, madam. Yes, sir.
My lord, item 256, 257, 258, all those matters. my lord.
If you are home and virtual mode,
No,
what the matters for dismissal.
I understand, my lord. 244, we didn't even expect, my lord. In fact, we have been waiting for that matter for a long time. Last time, senior counsel also argued the matter in part. Your lordship wanted to.
Top of the list, sir. Dismissal matter is top of the list.
Yes, my lord.
But you have to wait today. Huh?
No, 244 is not under a dismissal caption, my lord. 244, in fact, is a final hearing.
Today I put for dismissal, sir.
I understand, my lord. Your lordship, kindly consider, because your lordship has already heard the matter in part, that 244 also, senior counsel.
Sir, everyone has adjourned the matter for dismissal, push for dismissal.
Very well, madam. We'll argue matter next time. Your lordship may kindly this 256, 257, 258, my lord, kindly have it after 3 weeks. We'll argue.
Counsel. After 6 time, post after 2003 matter, sir. Okay, 3 weeks. Post for 3 weeks.
May I only consider, my lord, to remove it from a dismissal caption, the 244 matter. I'm sorry. Very well, madam. Very well. Deeply obliged, madam. Sorry for my absence of 244.
56, 27, 28. Post for 3 weeks. That was call for appellant. And or for the sponsor and Yes. Yes, madam. 59. Okay. నెంబర్ మార్చలేదు అక్కడ ఓకే వెళ్ళలేదు మేడం అంతేనా కదా వచ్చి అయ్యారు వచ్చాయండి both sides for dismissal after 3 weeks.
Item number 260, P. Srinivasrao, T. Balmohan Reddy, Raghuveer Reddy.
On both sides. Both sides. For dismissal after 3 weeks. On both sides for dismissal after 3 weeks.
Item number 264, Deepak Bhattacharya, Murali Narayan Bas, Kishore.
Presenting whom? 64. Yes, 264. Yes, only one. What is the issue, sir? Last 2 times you are asked for time. Huh? Not 6-9 and 12-9, 12-10 also. What is shoot for? Take care of money. I don't know, sir. Canada Bank filed. I think should have dismissed for money records should. On 2003, 99, 98 suit. 2003. Against the Hyderabad Stock Exchange Limited. Most for upland 6 time, post after 2 weeks.
Item number 265, Manjari has come framework from market.
Yes, madam. Sahadan also there, madam. She was small rather. Post upland 6 time. One of the respondents. Post after 3 weeks.
Item number 266, Dubai Gokhale.
One post upland. Post dismissal after 3 weeks.
Item number 267, Manjari has come SMS Sharma.
After submission, credit approval 6 time. Post after 4 weeks.
Item number 268, M. Govind Reddy, M. Soha.
On both sides, post for dismissal after 3 weeks.
Item number 269, J. Prabhakar, NLT Booking.
There is it, just now it clear. What's what matter? 66. On both sides, post for dismissal after 3 weeks.
Item number 270, DV Akash.
Yes, madam.
Yes, Ravinder, DV Vijayasagar. After 2 weeks.
Yes, sir. Ready? Look at both sides. Post after 4 weeks.
Item number 271, Vivek Jain, P. Venugopal.
Yes, sir.
We find no restrictions memo in this matter.
Yes, cost for the. Upon submit that, you have no restrictions from the client. Another step, Japanese dismissal no non-prosecution. Sir. Non-prosecution. What is the register number, sir? Of the pre-approved submission. They find memo in USR number
109808.
9808. Waiting there. They are not supposed to apply. Not the same. Okay.
Item number 272. The
Yes, madam.
company has gone to the last.
The petition to not place on record. As such, a lot of my access to place them on record. The ideas of 2006. These 2 petitions were mistakenly patent CC 84 2005. Store 2004.
Could I hear a gentleman?
MP 14460 of 2006.
And today listed only IA number 7 of 2004, 8 of 2004, 19.
These two IAs are of 2006, Your Lordship.
Okay, చూడండి clear. No, madam. LR petition, abatement petition.
There is one LR petition and there is set aside abatement to bring on records proposed respondents 12 to 18. The MP numbers are 14460 of 2006 and 732 of 2006.
Not listed today, madam. Only.
They're not listed, Your Lordship. Even on the last quotation, these were not listed. I made a specific mention. So, Your Lordship had directed us to put them on record. Despite that, it's not there.
No directions, so they're only just requested. Last occasion, in the request for
Because the file they were not pleased with those IAs are not those. Numbered as IA 1 or IA 2006. These particular two IAs have
Madam, first you have to send your clerk to the registry.
I have personally gone and checked, Your Lordship.
Then they give copy, then give one number is there, then copy to the registry.
What's placed in the file, Your Lordship?
Not this guide fund. The problem.
Because I put it in
Not listed also in there. All this is not listed. Yes.
I will request that these MP numbers may be noted.
Okay.
And direction will be given and then accordingly the IA.
The IA number?
CCCA MP 14460.
CCCA MP, so also. Not listed at same as necessary certification of this man. For the same, listed at to put up the first one, so post after 2 weeks. Yes. Over both sides, post for dismissal after 3 weeks. Over both sides, post for dismissal after 3 weeks.
Item number 278, Pawan Kumar.
Lordship.
Yes, sir.
These are connected matters, Lordship. CCCA of 319 of 2004 and CCCA of 320 of 2004. And those items have been posted for 2011. Kindly post these matters also the same date, Lordship.
Apparent submits that. These matters are both matters. I 215, the CCCA number
319 of 2004.
319.
319.
Yes,
and
yes, sir.
320 and 320 of 2004.
And the post on 20th/11/2023. Yes, sir.
Obliged.
Item number 277, TVS Kumar.
Apparent post for dismissal of 3 weeks.
Item number 278,
Where is he? On both sides, post for dismissal after 3 weeks.
Item number 279, D. Srinivasa.
Yes. Item 278. Elections cost per applicant, post after. Yes, I have seen, but we are not here. That's why post for that. 278. Elections cost per applicant, post after 2 weeks.
Item number 278, D. Srinivasa.
Post after dismissal after 3 weeks.
కోర్ట్ ఆఫీసర్ గారు 244 ఎప్పటికి పడింది చెప్పగలుగుతారా? 244